Good afternoon, everyone. Welcome to the Planning Commission meeting of November 17th, 2016. Ms. Rodriguez, would you call the roll?
Commissioner Thompson?
Here.
Commissioner Schwartz?
Here.
Commissioner Lodge?
Here.
Commissioner Jordan? Absent. Commissioner Higgins?
Here.
Vice Chair Peugeot?
Here.
Chair Campanella?
Here. And I want to thank Ms. Ostringer for joining us today in Mr. Vincent's absence. Thank you. Ms. Ghilardi, are there any requests for continuances, withdrawals, postponements, or addition of ex-agenda items?
We have none, Mr. Chair.
Okay. Any announcements or appeals?
We have no announcements.
Okay. Our next item will be review, consideration, and action on the following draft Planning Commission minutes and resolutions. Minutes of November 3rd, Resolution 2916 on 1400, 1700 blocks of Cabrillo, 1414 Park Place, and a PC Resolution 03016-1127 Bath. And I believe all the commissioners that are currently present were also at this meeting, so we shouldn't see any abstentions, I do not believe. So any questions or comments on the minutes or the two resolutions? Okay, seeing none, can we have a motion to approve?
Move to approve. Second.
Okay, we have a motion to approve and a second. All in favor say aye.
Aye.
Aye. Okay, that's unanimous. Next, we'll open a public meeting for any comments from the public for an item not on this agenda. Does anyone wish to speak? You will have up to 2 minutes. We have no speaker slips?
We do not.
Okay, seeing none, I'll close the public meeting. Our next item is an environmental hearing, application of RRM Design Group for the property on 1837.5 El Camino de la Ruz. So, Ms. Kennedy, you'll be doing the staff presentation?
Yes.
Okay.
Thank you, Chair. This is an environmental hearing for the project proposed at 1837.5 El Camino de la Luz. The purpose of the hearing today is to just receive comments on the draft environmental impact report from the public and from the Planning Commission, and no action will be taken on the environmental document or the proposed project today. The draft EIR is in the middle of a public comment period. It began on Monday, October 17th. It extends for 45 days, so that will be through Wednesday, November 30th. Here is a map of the proposed project area located here along the ocean at this arrow. It's close to La Mesa Park, and this gives you the location at the end of El Camino de la Luz here. Also, here's an aerial view of the project location. I'll point out this area here is the flat area on the project site. Project site extends down to the ocean and extends down to the Lighthouse Creek to the right. And it is a vacant lot. Here's a figure from the environmental impact report, just to point out a few features. Looking towards the ocean, the proposed project property, the proposed building site is in the red area where the home would be proposed. Lighthouse Creek along here, access driveway from the end of El Camino de la Luz here, the Lighthouse Creek Bridge right here, and then La Mesa Park. Here are some photos from the EIR of the existing condition on site. This is the relatively flat area on the site where the proposed residence is to be located. I'll give you some background on this project. It has been around for quite some time. It was originally submitted back in 2002. The application packet was deemed complete in 2004. Environmental review began, an initial study and draft mitigated negative declaration was prepared in 2005. At that time, there were 2 environmental hearings at the Planning Commission, and it was determined that an EIR should be required to evaluate the public views, specifically from La Mesa Park area. So a visual aesthetics impact analysis was prepared. In 2005, there was a revised initial study, and EIR scoping hearing occurred at Planning Commission to determine the scope of the EIR. Subsequently, in 2006, a revised initial study was prepared, and that also included updated bio report and information. The draft EIR was prepared, and in 2007 there was a hearing at the Planning Commission, and the EIR at that time, which was the first draft EIR, included an analysis of visual aesthetics and geological resources. The proposed final EIR was prepared, and the coastal development permit application was presented at the Planning Commission in 2008. At that time, the Planning Commission did not certify the final EIR. Rather, there was a request from the Planning Commission to have the applicant implement one of the mitigation measures that was included in the EIR. Mitigation measure GO3A was a measure to have the applicant owner determine whether there was this bedding plane fracture, this geological feature on the site. It was a mitigation. Like I said, it was determined that this should be done prior to the EIR being certified. So subsequently, the geologic investigation occurred to see if this fracture did occur on site. In 2009, there was this investigation, and it was determined that there is no plane fracture that was previously thought to exist. And that actually, there was a trench on site. Maybe some of you saw that. A trench investigation was done back in 2009, and on that flat area on the site, and that was the location. Again, there was no plane fracture found, and there's a report concluding that. Something else that happened was in 2009, there was a Superior Court stipulated judgment regarding the access to the site. The stipulated judgment lays out all the existing access easements associated with this project site. In 2011, there was an additional slope stability analysis completed, and that report stated that there are no slope stability impacts. In 2012, a first revised draft EIR was prepared. There was a Planning Commission hearing on this EIR and also a concept review of the revised house design that was being reviewed at that time. The first revised draft EIR was reviewed. We received comments, so we were in the process of responding to those comments. The EIR was being updated and was being revised to address the issues raised by the comments in the public comment period. And then the project was delayed. Again, there was a lawsuit regarding that trench, and that lawsuit delayed the project for quite some time. When that was resolved, we, staff and the consultant, worked on the second revised draft EIR. So that's the document before you today. There were revisions made to this based on comments from the last EIR version, and there was a need for some updated information given the time that had passed. This new second revised draft EIR includes a revised location of the top of Bluff. It includes an updated rate of Bluff retreat. It shows the location of the top of Canyon Slope. There's a new Canyon Slope stability and erosion analysis report prepared. Also, this draft includes a evaluation of the current design. This design has been in the works since 2007, but the previous EIR analyzed the original house design. So this EIR removes the previous house design and analyzes the current design, which was, in fact, a response to the visual impact comments previous. So then this new design in this EIR has a lower height than the previous. And then based on this design, the visual aesthetics analysis was updated and the geologic analysis was updated. Other changes include an updated policy analysis section, an updated biological resources section, and then a new section on impacts found not to be significant. I'll give you an overview of the impact analysis in the EIR. Class 1 impacts are significant and unavoidable, but the second revised draft EIR that we're reviewing today does not identify any Class 1 impacts. Class 2 impacts are potentially significant, but that they can be avoided or reduced with mitigation measures. The EIR analyzes visual aesthetic impacts and geologic hazard impacts, and other Class 2 impacts that were determined from the initial study are biological resources, hazards in relation to fire, transportation, and water resources, and I'll go through each of those. As I said, the original design in the original EIR would result in significant impacts to important public scenic ocean views from areas around La Mesa Park. And this was discussed in the previous EIRs. There were potential impacts that could be reduced with mitigation measures, and these were essentially revisions to the design which have been made. Here's a slide of the original design that was evaluated in the previous EIR, and here's a photo sim of that, and this was included in the original EIR. And I show these because you can compare these to the current design. So at this point, when we reviewed this in the original EIR, it was determined to be a significant impact and that the project should be reduced. So we have a revised project being evaluated. These are the elevations of the proposed current design. Here, you'll note that it does cantilever over the canyon slope somewhat on the side. Here's a cross-section of the proposed project, just some statistics about the project. The upper level's about 837 square feet, the lower level 777 square feet, and there's a 475 square foot garage. The height, which is lower than the previously reviewed project, it's 25 feet max here and 15 feet max on this side. And I wanted to note that this is smaller than the other home, majority of other homes in the area. As part of the visual aesthetics analysis, this is one of the figures here. The yellow areas are the photo sims that I'll show you looking at towards the project. So this is a photo sim of the currently proposed project located at what we call the benches area in La Mesa Park. Here's a view a bit closer in from the bridge, and one further away from the further into the park. Based on this analysis, we've determined that there are two mitigation measures that should apply to the project. There's potential impact that the use of bright or contrasting colors would have the potential to degrade the important public scenic views. Therefore, AES-1 is a mitigation measure to have the colors approved by the Single Family Design Board and to have them require neutral colors. And also a potential impact that the landscaping could reach a mature height and obstruct public scenic views. Therefore, the mitigation measure is to have the landscape plan approved by the Design Review Board and that the landscaping not to exceed the height of the proposed residence. The conclusion is that the project's current design would not result in a significant aesthetic impact to important public views. In regard to geology, there have been numerous reports prepared for this project. I'm going to go through a few of them here. There was a peer review done by Anna Kuchin back in 2005. It was a summary of 17 previous reports. This was in your previous EIR. There was a slope stability analysis included, and the conclusion was that the project site is stable. Followed up with a geologic inspection trench report, and this was in relation to the mitigation measure that Planning Commission had requested be implemented. That report was prepared. The previously reported bedding plane fracture does not exist, according to the report. And then on the follow-up slope stability report was prepared in 2011 to further look at the slope stability analysis, what types of potential failures could occur on the site, dealing with any additional weight of the house and groundwater issues. That's included in the EIR, and conclusion, the project site has been determined to be stable after the proposed development. Since the last EIR that you reviewed, there have been a few new reports prepared. So the Ocean Bluff Erosion Retreat Study was prepared in 2013. This locates the revised top of Bluff. I'd like to say that the City and Coastal Commission staff concurs with this top of Bluff location. There's a revised Bluff retreat rate. It is more site-specific, and it was more accurate than previously. It's been determined to be 1.02 inches per year, which results in 7.6 feet from the top of Bluff. The Coastal Commission staff geologist concurs with this, although I will state that we had conversations with Coastal Commission staff, and I forwarded to the Planning Commission some notes from that conversation where the geologist does concur, although he did say, and we're aware that he said that Coastal Commission does prefer a 25-foot setback from the top of Bluff, but again, he did concur with the conclusions of the report. Here's a figure showing the top of Bluff location. So the top of Bluff is in red, and then we have the 75-year Bluff setback, which is 7.6 feet. That's located here in blue. Another report prepared for this EIR is the Canyon Slope Stability Analysis and Erosion Study. This evaluated the stability and erosion potential of Creek Canyon Slope. It concluded that the project site is stable. It recommends a 10-foot setback from the top of the canyon slope if conventional foundation were to be used, or if the fill were to be replaced with engineered fill. However, no setback would be needed for a caisson foundation, which is what the proposal includes. Again, Coastal Commission staff geologist has concurred with, read and reviewed, concurs with the conclusions of this report. Here's a figure that shows this. The green line is the top of canyon slope. This other line would be a 10-foot setback if a regular conventional foundation were to be used. It's the recommendation that it be set back. However, caissons will be using, so that's not required in this case. It's just a cross-section of, from this location here of the site. You can see where the Lighthouse Creek is. Some fill here. There were borings through the fill as part of the slope stability analysis. Here shows the top of canyon slope location. After all the studies were evaluated, we did determine that there are some mitigation measures that need to be applied. The potential impact is that storm drainage system or an increase in irrigation would have a potential to result in a significant slope stability impact. Therefore, the mitigation measure GEO1 would be applied, and that would be to maintain the drainage system and limit irrigation use. There would also be the potential to adversely be affected by fill soil or subsidence or expansive soils. Therefore, we've added the mitigation measure GO2 to design that the design of the caisson foundation system be approved by a licensed engineering geologist or geotechnical engineer. The conclusion is that the implementation of the mitigation measures would reduce the potential impacts to less than significant levels. There are other Class 2 impacts that were looked at in the initial study in regard to biological resources, hazards, transportation, and water resources. I'll go down those briefly. There are a number of mitigation measures from the initial study that would be applied to the project, and they're listed here, mostly in regard to the restoration plan, installing appropriate landscaping plants, using the appropriate irrigation system, implementing appropriate water quality measures during construction. We required an updated biological report in 2013, just given the amount of time that had passed since the previous one. Additional measures were proposed in that report, and we've added them to the project as mitigation measures, and they're listed here to some best management practices to prevent soil erosion, monitoring, protecting nesting birds, and such. There's a question about the top of bank versus the top of canyon slope and that distinction. The top of bank was determined to be located close to the creek in the previous bioreports of 2002 and 2006. It's a feature that relates to the function of the hydrology of the creek, and at that location, which I'll show you, is greater than 50 feet from the proposed building is greater than 50 feet from the top of the bank showed. This is a previous site plan. And also, someone had asked the site visit about the previous location of the top of Bluff, so I can show that to you here as well. You may recall, if you were involved earlier, that the top of Bluff was shown down here, and that circled around to the top of bank location. So the top of Bluff was reevaluated, and as you know, is much more closer up here in this area, and that's one of the main changes of this EIR. This is where the top of bank was located in those bioreports previously prepared down here. Canyon slope is used in the geological reports to analyze the stability of the slope. It's also a term that's been used by the Coastal Commission for this type of feature when in discussions with them. That's how they refer to this area where you've got an ocean bluff and then a creek or canyon that circles around. And we discussed looking at it from terms of coming to a determination about the top of canyon slope location. We did determine it using the top of bank definition, though, that's in our ordinance, which is actually just used for the Mission Creek, but we use it often for other creeks. And it is the intersection of the general plane of the slope with the upper level area. So you can see that when you're out on the site, that it is how the creek slopes up and then becomes a flat area above. If there were additional setbacks from the top of canyon slope as shown, that would not allow any development. As you could see out on the site, that is the flat area. Any kind of setback of 20, 50 feet would preclude any kind of development on the site. The proposed development is greater than 50 feet from the incised creek, actual creek location. There's a proposed large restoration area, over 8,000 square feet, between the creek and the proposed residence. And the restoration and maintenance plan would be subject to review and approval by the Creeks Division. Creeks Division has provided some preliminary restoration comments to the applicant about what types of restoration plantings would be appropriate in that area, and they would be reviewing and approving that final plan. Switching to hazards, there is a potential impact that the location, which is adjacent to native vegetation and also the narrow width of the access driveway, resulted in fire department requesting these mitigation measures, which are to provide automatic fire sprinklers in the new home, to provide a monitored fire alarm system, to have the project, although it's not in a high fire area, to construct the new residence with high fire hazard area construction requirements, and also to maintain the sprinkler and alarm systems for the life of the project. Another Class 2 impact that was identified is that there's a potential of a vehicle access related impact. T1 was a mitigation measure that was added to the project, and since the beginning when the first initial study was prepared, and this is taken out of the conditional certificate of compliance that is on the property that states that before they can develop, the owner must provide evidence that there's access that exists that is substantially the same as what was there when the lot split occurred. So this issue has been resolved, and the 2009 court decision laid out all the different access easements that exist, and here's an exhibit showing that. Right here is El Camino de la Luz Street, and then there's a access easement for the property. The property site's here. Access to the property is 15 feet wide. It narrows to 7.5 feet wide for just 7.14 feet in length. And then it opens up and is a little bit wider, 9 feet, I believe, right along here to the project site. As I said, the access width varies, with the narrowest point being 7.5 feet for a length of 7.14 feet. Transportation Planning has reviewed this and have concluded that the access width is acceptable. The fire department has concluded as well that it's acceptable as long as those mitigation measures that I just mentioned are implemented as part of the project. Another Class 2 impact that we looked at was the potential for short-term water quality impacts to the creek during construction. The mitigation measure is a city approval of the proposed grading, drainage, stormwater, and project development plans. There are Class 3 impacts. These are less than significant impacts. They were identified in the areas of aesthetics, air quality, cultural resources, noise, population housing, public services, recreation, greenhouse gas emissions, agriculture, and forestry resources. And we have some recommended measures that were identified to further reduce these already less than significant impacts. I'm not going to read all these, but they are in regard to air quality, each issue area, cultural resources, noise, public services, recycling, transportation, water resources. Also, there's a policy analysis section. The draft EIR states that the project is potentially consistent with all applicable Coastal Act and local coastal plan policies, especially in regard to biological resources, visual quality, and hazards. The EIR includes an alternatives analysis. The two alternatives are a no project alternative and a smaller project alternative. The smaller project would be approximately 300 square feet smaller, with the upper level garage and a lower level living area. Here's a site plan showing that, how that would be located on the site. Here's a photo sim of this smaller alternative, and it's at the same three locations that I showed you previously on the current design. For the no project alternative, of course, this would not meet the owner's objective for a new residence. The smaller project alternative, there is a slight reduction in visual impacts. It's very minor, and it would not be required to reduce any impacts to a less than significant level. There are similar geologic impacts. However, it would be the environmentally superior design to the proposed project because it is smaller. Our recommendation is to receive comments on this draft EIR from the public and the Planning Commission. Again, no action will be taken on the document today. The public comment period extends through Wednesday, November 30th. Comments can be sent to the Planning Division, to the Planning Commission Secretary. They could be mailed or emailed or delivered directly to the Planning Division. Our next steps are, we're accepting comments, like I said, through November 30th. We will prepare responses to all those comments, and then we will prepare a proposed final EIR. And that final EIR will be brought to you at a PC hearing for you to certify the document. That is the end of my presentation. Thank you.
Okay. Thank you, Ms. Kennedy. Does the applicant need some time for presentation? Okay. How much time would you need, do you think?
Maybe 5 minutes.
I'll give you 10 minutes, just so
Thank you.
you don't have to rush. Thank you.
Good afternoon, Mr. Chair, Commissioners. I'm Detlev Pikert. I'm the architect, principal, and architect with RRM Design Group. I've been working with Dr. Barthels over the years on the project. And our understanding today is that you're here to take comments from the public, and we will provide comments ourselves, that we're not making a presentation on the design or anything like that. We also have some of our team members here. Richard Monk is an attorney working with us. Rick Gorman is a geologist from Earth Systems, in case you have questions regarding the geology, et cetera. And then, of course, Dr. Barthels is here if you have any questions of him. We're just going to do one brief presentation Richard Monk is going to make that presentation. It has to do with the access easement because that seems to be one area of contention that the neighbors continue to be interested in, and so he's just going to clarify some information on that in that regard. Thank you.
Mr. Monk.
Good afternoon, Mr. Chair and members of the Commission. I'm Richard Monk. I'm the land use attorney for the applicant. Detty Pikert will be following along with a PowerPoint as I speak. As Kathy has told you, the property is benefited by a number of road access easements, which consist of 15-foot wide easements off of Camino de la Luz extending south, and then a 7.5 wide easement at the pinch point opposite the Franco property, and a 2.5 wide easement which combines with a 7.5 easement to provide 10 feet of width. At that one area for 7.14 feet in length, the 10-foot wide easement narrows to 7.5 in width and then becomes 10 feet again in width until it reaches the Morgan property, where it narrows to 9 feet because of an easement grant by Barthels to Morgan back in 1995. However, in that agreement, the parties confirmed that Barthels has a combined record access easement of 10 feet in width. In fact, the agreement states, and I quote, the 10 feet being the 7.5-foot driveway easement plus the 2.5-foot other easement on the Peterson side of the center line is valid and still existing. That was page 3 of the November 17, 1995 agreement. That constitutes an admission by Morgan that there is 10 feet of access. The November 17, 1995 Morgan-Barthels agreement also confirms that the 1-foot easement strip granted to Morgan is concurrent with the combined 10-foot wide access easements. So the combined 7.5 plus the 2.5 wide easements extend 145.77 feet to the Barthels property. Now, the neighbor opponents have long contended that a certain 1994 Court of Appeal opinion established lack of access. In fact, the Court of Appeal opinion acknowledged that the property still has access, albeit not a continuous 15-foot width strip, and the court actually referenced the 7.5-foot wide easement. However, that and recognized the 7.5 wide easement, but the additional 2.5 wide easement, which Barthels also has, was not even an issue in that case. So, as already discussed, Mrs. Morgan confirmed in the November 1795 agreement that the applicant has the benefit of both the 2.5 and the 7.5 wide driveway easements, and the staff report accurately states, and I quote, that the subject property does have access easements that vary in width from 7.5 to 15 feet. In or about 208, some of the neighbors who had demanded that the Planning Commission ordered that the certain additional geologic work be performed by Dr. Anakuchin, then blocked the access to allow Dr. Anakuchin to perform that work. As a result of that, our law firm had to perfect our client's legal easement rights in a court proceeding, and Kathy Kennedy has quoted some of the passages out of the court stipulated access order where the judge said, all parties acknowledge that the access easement on the Franco property is limited to 7.5 feet in width on the southern 7.14 feet of the Franco property. So recent letters to your commission from some of the neighbors alleging that there's only 6.5 feet of access at that pinch point is absolutely false and flies in the face of the judicial admissions and the Superior Court's order. City staff has opined that a majority of passenger vehicles could access the site. As Ms. Kennedy has told you, the fire department has reviewed the access and has no problem with the access provided that those mitigation measures H1, H2, H3, H4 are imposed. I was going to talk about the lot split approval, but I think staff has adequately covered that and has actually made the determination that the requirements of the certificate of compliance have been complied with, and I don't have any further comments. Thank you.
Thank you. Anyone else from the applicant team at this point, or they're available for questions of the commission? Okay.
And we would like to reserve the opportunity to rebut comments made by the opponents to the project if, should it be warranted. Thank you.
Okay. Thank you. You'd have about 4 minutes, unless we started asking questions, and then it would be up to us to get the responses in appropriate amount of time. Okay. We have 2 combinations that have been made for speakers of the public. I'm going to open the public hearing. Sabina Venkus will have a total of 8 minutes, and time has been given to Ms. Venkus by Elise Cozart. Is she here? Okay, thank you. And then Daniel McCarter. Okay. And Sarah McCarter. Okay, great. So you will have a total of 8 minutes to give us your comments.
Thank you. It's nice to be here. My name is Sabrina Venskis of Venskis & Associates, and thank you for the opportunity to make my comments today. I'm a lawyer. I'm with a public interest law firm, again, Venskis & Associates. We're dedicated to providing high-quality legal services to traditionally underrepresented people, environmental groups, citizens groups, civic groups. We serve clients throughout the state of California. I've not been before you before, so thank you again for this opportunity. We practice environmental, natural resource, and land use law. We also are a firm that represents tenants against slumlords, people that have been fraudulently evicted, so on and so forth. So that's really our specialty, and we also specialize in open government law. So I just kind of wanted to give you a basic understanding of who we are. We're here today representing the citizens to preserve and protect the Mesa's coastal bluffs. That's a number of people in and around the Mesa there who are concerned with development on the bluffs, and in particular with respect to this project, the detrimental effect of this proposed project on the environment and our natural resources. I wanted to share with you just the general context of these comments, and that is this. Not really sure why we're still here with respect to this project. I understand there's a long history regarding this project, but the fact of the matter is that the lot is not a legal lot. At the time it was created, it did not comply with the requirements of the city ordinance then 2488, which required certain access requirements for public health and safety. So it's not a lawful lot. It also was not properly recorded with the city. The applicant understood that it was not a lawful lot. When he purchased the property, he found that the lot did not have sufficient access so that he could not develop it under law. That's why he sued the title company. He sued Santa Barbara Title Company in the early 90s and claimed that he could not develop his property because it was not a lawful lot. And therefore, he wanted just compensation for the entire purchase price of his property, in addition to inflation, in addition to collateral costs, in addition to special damages. He was fully compensated for the purchase of his property because he said that he could not develop it, and he understood he could not develop it as it was represented on title. And now he comes to the city decision makers and asks to develop the property, even though he's already acknowledged that he can't develop the property and got compensated for that. So that's the context in which we're operating today, and my comments are offered to you. With respect to the EIR is deficient. I don't want to go too far into why the EIR is deficient. I'm going to give you some broad strokes on that, because really at the end of the day, this property can't be developed, and the applicant knows that, and is why he sued and why he got compensated by the court. And again, that was in the early 90s. The 2009 court decision has no bearing on whether or not this applicant has sufficient access to develop the property. The lot is not legal. The lot doesn't have 15 feet of access, and so therefore the issue is that there is no right to develop this property. With respect to the EIR, there are some pretty significant deficiencies in the EIR. Number one is the acknowledgement of whether or not this is even a legal lot or not. There's no discussion of that, and it does not address the fact that since 1958, this city has said you need 15 feet of access. With respect to the biological impacts, the DEIR claims that the proposed project will remove non-native species that have little biological value, so therefore it implicitly finds that there are no sensitive species impacted. But that conclusion is not supported by substantial evidence. The biological assessment done on behalf of the applicant is insufficient to support the DIR's findings because there were no surveys done on the site for sensitive invertebrates, even though the rare invertebrates have been found in Santa Barbara and on the Mesa. The DIR does not appear to conduct any rare plant surveys. The plant survey protocol that supports the DIR's findings is a mere 2-hour survey conducted on August 17th, 2013, and that's in midsummer when most plant species are no longer identifiable. The geological findings are not supported by substantial evidence. The required bluff and creek setbacks don't take into account the potential for landslides, nor do the setbacks contemplate or incorporate the risk of landslides at the project site. The mitigation measures proposed don't provide sufficient detail in order to ensure that they'd be enforceable. The DIR's conclusion with respect to land use policies are unsupportable because the analysis is missing on a number of the policies, and we will submit those in detailed comments as to what policies have been ignored or not sufficiently analyzed. The DEIR does not analyze or evaluate ESHA. The DEIR findings regarding shoreline access are not supported by substantial evidence. The visual quality analysis is deficient. The determination that the project is potentially consistent with the Coastal Act policies, including LCP policy 9.1 related to visual resources, aren't supported by substantial evidence because the figures in the mitigation measure analysis indicate the project as proposed would obstruct public views of the ocean from both the La Mesa Park and the bridge. Finally, because I only have about 1 minute left, I did want to share with you where I think the EIR is most deficient, and that is the feasible alternatives analysis. CEQA provides that agencies must engage in a reasonable range of alternatives, and here we only have one alternative, and that's not a reasonable range of alternatives. The alternatives must avoid or substantially lessen any of the significant effects of the project. And here, because there's only one alternative and it's only slightly smaller than the proposal or the actual requested project, it doesn't actually reduce the significant impacts to a level of insignificance. For example, the proposed alternative has only slightly less total square footage of 1,200 square feet versus 1,600 square feet. It'd be taller in many of the areas than the existing project, requires a greater amount of excavation to complete the project. And in addition, the proposed project and alternative presented would have substantially similar inappropriate bluff and creek setbacks, and we would be built in the same area of the site as the proposed project. So it's not a true alternative option that substantially reduces environmental impacts of the proposed project. There, of course, are alternatives to the project, a much smaller project, perhaps 600 feet, 900 feet. Nobody says that a house has to be 1,200 feet or 1,600 feet.
Okay, thank you. You'll be.
Oh, thank you. I'm sorry.
Okay, that's all right. You'll be submitting something to our staff.
Yes,
as well,
thank you.
Comments before November 30th. Correct.
Correct.
Okay.
Thank you.
Okay, Mr. Franco, you're going to have 8 minutes as well. Hold on one second here.
If I may, Mr. Chairman, if we can.
Yeah, you can, I'll start when you get set up. Okay, just want to make sure, let's say, Mr. DeBourbon, are you here? Thank you. Mr. Morrison, Thomas Morrison, thank you. Nancy Brock, thank you. And in your own time, of course, so you'll have a total of 8 minutes.
Thank you very much, Commissioner, Mr. Chairman and Commissioners. My name is Ray Franco. I reside at 1835 El Camino de la Luz. I've been involved with this project for over 30 years. I understand it's the longest pending project in the city of Santa Barbara, and maybe in the history of Santa Barbara. Nonetheless, I'll try to be as brief as possible and quickly with my presentation. I agree with a previous speaker that the record indicates that the applicant does not have the 15-foot easement that was originally presented to the City Council when the lot split was approved. Whether you change your mind later on or something, that's different, but the conditional certificate of compliance, which the applicant asked for because he was denied an application by the city attorney, erroneously, but he was denied his rights to application, specifically said that the record indicates that he had to have 15 feet, and that's why a conditional certificate of compliance was issued under the MAP Act. There's also, I just want to clarify something because I believe somebody erroneously, or Mr. Monk erroneously said that I was claiming others. This is the original settlement agreement, signed by me, signed by the Dr. Barthel, signed by the law firm for the applicant. And yes, we agreed that there was a 7.5-foot easement, but there's also a list of encroachments that were to be preserved at that time. And as of 2 days ago, I was told, well, you're going to tear down your wall. So that being said, that's not the amicable way to get a project done. But this is the original, okay, signed by all the parties. Now, if I may, what happened to it? You have it on? There we go. Just to go through the history of the project, go back to 1928. 1928, you can see Cliff Drive and Oliver. You can see where the creek is. This is the creek, and this is the site. And pay attention to this white spot that's on that site. As you can see, when we focus in on that site and the white spot again, all the way from Oliver, all the way to the creek, is an area subject to slides. Okay, we know of the 1978 slide, and it continues. That started way before there was any development there. That's just a natural course based on wave action and the erosion of the bedding plane supports down at the beach. There was a long argument as to where the top of Bluff was, and in fact, there's different interpretations of it, but I think this is where we all agreed at this point, and that took literally 10 years to get to this point, to agree on what the top of Bluff was. But that also may be insignificant. At the meeting that you had on site, I asked, where is the corner of the house? Where's the most prominent corner of the house? Most prominent corner of the house is right there. Okay? You saw a rendering earlier by the applicant's architect that showed this green space in front that was very nice and beautiful. But in fact, there's a cliff right in front of there where there will have to be a 100-foot caisson in order to support it. Why a 100-foot caisson? Because that's where the bedrock is. That's where the basalt rock is, not the Monterey Shale that's there. Now, there was also a statement made that there was no fault and no break or fracture in the bedrock. This is from the applicants, from the EIR itself, indicating where the two fractures in the bedrock are. that they have now discovered. This one they knew of before, and then this one is the one because it traces back to the interrupted bedding. I will show you what the interrupted bedding means. But in fact now, those are also the areas where you have the slide material that was present, and in some of the photographs that I'll show you are covered now by vegetation. This now is exactly the same, projecting exactly the same where the geologist for the applicant showed and indicated that there would be fractures in the bedrock. The white material that I was alluding to in the previous shot was not only this material over here next to the creek, but also what is now hidden by the block failure that was there earlier. Now, this is the real danger and where the slides have been. They're called planar failures. At 36 degrees, when you measure the dip and the strike of the underlying Monterey Shale, that's basically where they go. But that's not where Dr. Anakuchin did his study. His study did not follow the same angle as the dip and strike of the existing Monterey Shale. This is the 1995 slide. Part of what you see there is the same thing that you saw in the earlier slide or in the earlier photograph from 1928. And I'll go down a little bit more. This is at the other corner. The other corner where basically the last caisson, the most proximate caisson, would end up being going over there. This has failed. We used to walk up this bluff. And I'll go back to one photograph which I think is important, and I apologize for this.
You have about a minute and a half, so
Okay,
you might just want to pace yourself.
So what we have an argument with is what was actually stated on site the other day, is that the wave action does not have any impact on the bluff, and that is totally false, absolutely false. Either somebody didn't understand or doesn't know. And the idea that caissons can stabilize the hill is false. This is the legacy that we're proposing by this project. But these are 40-foot caissons. What they will have to put up there are 100-foot caissons. Now, it may not be in my children's lifetime, it may not be in my grandchildren's lifetime, but certainly in some of my great-grandchildren, they will have to face that. Because the Coastal Act says not only do you look at the views from the park, but you look at the views in the future of what's going to happen there. Okay? And if you want to, I apologize. We need a clock over there, by the way. If you want to know, what the bedding planes are and what the water can do, the most extreme right on this picture over here, that's where the bluff used to be. But that's what water does. And as you can see, the actual basalt bedrock that is there is worn away. As you get closer and closer to today's date, it's much more prominent.
Mr. Franco, why don't you take 20 more seconds because of your difficulties.
20 more seconds. I apologize for that, but I'll give you another one. Today, you can go to the Museum of History here in Santa Barbara and see one of the most important exhibits that I've seen here in many, many years. It's the Vancouver expedition that shows the first record of the coastal bluffs in Santa Barbara. If you look at that, you'll understand the importance. And the importance is that you are the stewards of our bluff. You are the stewards of our paradise that we have here. And we shouldn't give it away just because somebody wants to make a profit on it. And I apologize if I went over time.
Okay,
Thank you very much.
that's okay. We try to give you enough time based on your setting up technically. Thank you. Okay, let's see. Staff, do you have any comments on what's been said, or are we ready to go to questions from the commissioners?
I don't have any comments.
Okay.
Thank you.
I'm sorry. Commissioner Schwartz.
I was wondering if the attorney from the public interest law firm already has copies prepared for the commissioners, or is that something you're going to forward at a later date? I will forward it as soon as I... Okay.
Okay. We had about, let me set this up for you, Mr. Pikert, if I can. It was about 5 minutes. Okay, you have a total of 5 minutes left for additional comments.
Thank you, Mr. Chair. I don't think I'll need that much time, but responding to the attorney from the public interest group, talking about the lawsuit against the title company that Mr. Barthels was engaged in at one time, that lawsuit had nothing to do with the legality of the parcel. It was over what the width of the easement was, whether it was the 15 feet that was supposed to be the stated width according to the Tyler report, or whether it was the 7.5. So that's what that issue was about, not over the validity of the parcel. The parcel was actually created by a 1958 lot split approval long before Dr. Barthels ever acquired the property, many, many years before. And that approval of that lot split was never formally finalized. The lot split proceeded to the city's subdivision committee and was approved. However, the city required recordation of a written instrument back in those days to evidence the lot split within 1 year of the approval. And that never occurred. The subdivider then deeded the property, a fellow named Eaton deeded it to somebody named Brewer. That division was illegal because the condition of the lot split had not been complied with. Because of that, the city required a conditional certificate of compliance to be prepared and recorded, and that conditional certificate of compliance provides that the owner must provide evidence satisfactory to the city engineer that the owner of the parcel described herein substantially possesses the required amount of legal access that formed the basis of the originally approved lot split. That's what city staff says has been demonstrated by reason of the opinions of the fire department and the transportation division. So the lot was created back in 1958, long before Dr. Barthels acquired the property. The conditional certificate of compliance validates that that lot does exist, although it's subject to the condition on the conditional certificate. No action was filed by any person seeking to set aside or to challenge the conditional certificate of compliance, and the Subdivision Map Act provides a 90-day statute of limitations to challenge a certificate of compliance. So there's absolutely no judicial challenge to the validity of this lot. Thank you.
Okay, thank you. Let's see, I believe we have Mr. Franco's slides. Are they still up? Those are his slides that are still on the screen. Are those yours? No.
Mine right there.
They are yours?
Yes, that one is.
Okay, good. I just want to make sure we get back to staff.
Yes.
If we're making reference to anything of the slides. Okay, so now we go to questions from the Commission. Commissioner Higgins, please.
Thank you, Mr. Chair. So for staff, give us a quick primer over the terms, scientific or maybe terms of art again, with respect to the top of Bluff, top of Bank, top of Slope Canyon. My understanding is that within the confines of our regulations, we have top of Bank and top of Bluff to work with, but the top of the Slope Canyon is maybe an evolving term of art, and we don't have the regulations handy to stipulate a setback from that. Is that generally accurate from what I heard?
Mr. Chair, Commissioner Higgins, I'll try to find a slide here to refer to. So I'm showing the figure that shows the top of canyon slope here. That's from the canyon slope stability report. We do have a top of bank that was determined back in 2002 by the biologist in this location. When we were further evaluating this project, it was important to distinguish between the top of bluff area and how it turns and becomes a canyon. So we talked with the Coastal Commission and we discussed this with geologists, that it's important to figure out what this is called. It's not a top of bluff on this side, so we're calling it the top of canyon slope. Our Creeks Division has been out to the site. They've been involved in this project. I think it is their opinion that this flat area ends and that they would probably consider this the top of bank of the creek. We can argue that point. In the biology report previously prepared, it shows the top of bank down here, which really relates to the creek itself. And there is a lot of vegetation between that area and what we call the top of canyon slope that will be revegetated and in the restoration plan. So we have two different locations that we're talking about.
So
we don't have a required setback from top of bank at Lighthouse Creek, nor do we have a required setback in city ordinance from a top of canyon slope.
So we don't have a regulatory disagreement locally or within the city to exclude the Urban Creeks Council. In other words, they have a disagreement with us, but that's not a regulatory disagreement.
I would look at that as more of a policy, not even environmental, but a policy discussion that you can have regarding the kind of setback you would like between the proposed residence and the actual creek.
Okay, well, maybe some of my other commissioners will pick at that further. And to Mr. Chair, and maybe to City Attorney, we're not here today to provide an opinion about the subdivision, correct? That's not before us for discussion?
That's correct, Commissioner Higgins. We're just here to take comment and information.
Just a question maybe for the EIR consultant. Give us a maybe color commentary about how you would respond to the opponent's attorneys with regard to the rare plant biological surveys and the potential omission of any discussion of landslides. And I realize you'll have time to prepare a more lengthy response later after you see her written comments.
Certainly. The site has been surveyed several times for biological resources. That back in 2002, I think that included surveys for steelhead trout, any other species of concern. Red-legged frogs were also protocol surveys for that. The determination of both the original biological survey and the subsequent, more recent biological survey was what we would expect to find at the project site are species that are typical of urban disturbed areas that are tolerant of residential development. So that would be things like raccoons and possums and the like. There would be the potential for nesting birds in the creek area, and there's mitigation measures to do pre-construction surveys for occupied nests. That's for biological resources. This site has been studied extensively for slope stability issues, both the slope leading down to the creek and the ocean bluff. And those slopes have been determined by people well-versed in the field with lots of experience, that those slopes would remain stable after the construction of the project.
So, not to put words in your mouth, but do you feel as though we have substantial evidence here today to make our recommendation, or do you feel as though you may need time in the interim after public comments received formally to conduct additional surveys?
Commissioner Higgins, the appendices of the EIR include the slope stability reports. And
with regard to biological surveys?
Biological surveys and slope stability.
Okay. Thank you. One more question for maybe the applicant. Is there a public access easement? I saw somewhere, I believe in this document, there was somebody was making that suggestion or allegation, and we certainly saw evidence of a footpath down to the beach. Is that in any way recorded, or is there some form of a prescriptive easement?
To the best of our knowledge, there's no recorded public access easement. If someone has a document like that, we'd certainly be interested in seeing it, but we're not aware of it.
Thank you, Mr. Chair.
Mr. Thompson?
Thank you. I have a couple of questions for the staff. Number one, the definition of the top of the coastal bluff, I think it was on your slide like 32 or something like that. Yeah. Back two from there. That the red line looks a little strange. I've never seen a bluff line that cuts perpendicularly across the topographical features of the map. Why would the top of bluff be defined as going downhill across the topo lines, not follow the top of the topographic features around to where you have defined the top of the canyon?
Okay, so I might have help with this, but so this line is the flat area, essentially
yeah, that
right here.
sort of follows
and
the
then it follows
topographic
along
line.
to the, this would be the top of canyon slope.
Yeah,
so
and
it
then,
ends here. This, though, does relate to the ocean. It's still, there's area in between line where this relates to the canyon slope, and this area relates to the ocean bluff. So that kind of gives you a sense of this is more of a bluff location.
okay, I don't follow your explanation at all. Who came up with this defined top of bluff that runs perpendicular to the topographic slope? You know, top of bluff, the words talk about being on top, not running downhill. That's what is confusing in this, the way it's depicted.
It's due to the topography. This is just the way it is out there. There has to be some line or some location. I mean, I guess you could end it right there and say,
typically
there's
on
nothing happening,
a
but
coastal
there is
commission,
this is a bluff.
Typically on a coastal commission chart, they show the if there's a creek feature going into the ocean, they run the bluff around and encompass the creek. No, that's not done here, however, and that's my question. Why are we showing something that looks to be very non-standard? Why is that? What is it supposed to be telling us?
Commissioner Thompson, it's based on the topography,
right,
as defined by the Coastal Act. That line, the first time that I saw that, it was in the 2013 evaluation of the erosion rate at the project site, the retreat of the ocean bluff, and this has been reviewed by Coastal Commission staff, and they have concurred with the location.
The coastal policy says if there's a step-like feature, which that thing is crossing, that the coastal bluff is defined as the landward side of the step-like feature. And so that coastal bluff line is running right through the middle of it. That's the reason why I'm confused by it. So I'm going to leave it there, but I'm going to say that we need to have a lot more explanation in the EIR. Second question is the top of canyon slope. Is this an attempt to redefine something because the top of bank would be way up in the building zone? In other words, you said you used our methodology to determine where this so-called top of canyon slope was located. You used the methodology for determining top of a bank, but you don't define it as the top of bank. Why is that? Why are we differentiating between the normal top of bank and calling it something else here? We normally have not had top of canyon slope ever before.
Commissioner Thompson, Typically, not always, but typically, the top of bank has a hydrologic and geomorphologic relationship to the function of the creek. And the biology study that was conducted in 2002, using that criteria, identified a top of bank, which is down near the bottom of the canyon. However, based on the city's zoning ordinance definition of the top, if you can find that other slide, basically the top of the slope of Lighthouse Creek was designated where there's a substantial break in slope between the mostly paved area and where it starts to transition down into the canyon. Because that has no or very little relationship to the function of the creek, Coastal Commission staff recommended that we use a different term. But for the purposes of evaluating the impacts of the project, that line, that break in slope, could also be interpreted as the top of the bank. But we have used a different term at the recommendation of coastal staff to differentiate the relationship of that topographic feature and the function, that the hydrologic functions that occur in the creek.
So the Coastal Commission staff is the one that recommended that you differentiate? Okay. So following on that, on your next slide, you said that the Coastal Commission staff geologist concurred with the Bluff retreat numbers and so forth. Was he just agreeing with the methodology and the numbers, or was he agreeing to the setback that was proposed also? Because normally they want a bigger setback.
He agreed with the reports. He read the reports and agreed with the methodology and the conclusions. He did also state that in general they prefer a 25-foot setback, but even so, he did agree with the conclusions.
With the reduced setback? He agreed with the reduced setback?
He agreed with the retreat rate, yes.
Well, retreat rate, I know, but did he also agree with the reduced setback?
The setback is based on the retreat rate.
Right. But normally it's the retreat line plus. So the point is, did he agree that they would go along with a reduction of the setback from the retreat line?
There's not a reduction. There is a retreat rate, and that equals 7.6 feet. Maybe I don't understand your question. But overall, he did, just in general, he did read the reports, the final reports that you have before you, and agrees with the conclusions of those reports.
Two other questions that have nothing to do with slopes, but the proposal in here is for a vegetated roof as part of the aesthetics and so forth. My experience is the fire department will not approve a vegetated roof. One of my neighbors tried to do that following the T fire, and they were disallowed because the fire department has a mandatory no vegetated roof in the high fire zones. So was that an agreed upon thing with the fire department, or is that something that will be reviewed in the future?
We can look at that again. That was part of the original proposal. I know the project's required to meet high fire standards, so I'll have to check into that. And given the drought and things that have changed over time, that perhaps
well, I don't think it had to do with drought. I think the fire department's concern was for fire. If you have vegetation on the roof and it gets dried out, and it can be a source of fire. Okay, my final question is, I did not see anything in here regarding view analysis from the ocean. Did I miss it? Or did you not do it? Normally, we also look at view analysis of a project from the ocean looking back towards the land.
Commissioner Thompson, the EIR does provide an evaluation of how the house could be viewed from the beach. and it was determined to not be a significant impact. As you move further away from the project site out onto the ocean, the appearance of the house would continue to get smaller and smaller.
Sure, but also become more and more visible.
But it becomes less prominent on the landscape.
Okay, normally that's included in our evaluation of a coastal property, so I'll just leave it at that. Thank you, Mr. Chairman.
Okay. Let's see, Commissioner Schwartz, next.
Thank you, Mr. Chair. So in no particular order, let me start with where Commissioner Thompson concluded, which is the public views from the beach, which are protected views under the Coastal Act. So I'm wondering, do we have some sort of an analysis with like a time-lapse study looking at historic erosions, slides, potential for erosions, wave erosion, vis-a-vis the built environment, the structures, the engineering that would be required to support the proposed development from the beach looking up? For example, we had a member of the public, I think it was Mr. Franco, show us the view of what we're currently seeing in Isla Vista from the beach, from bluff erosion due to wave activity. Do we have any kind of anticipated visual simulation of what that could look like from the beach here over the 75-year window that we're using for some of our setback analysis?
Commissioner Schwartz, the evaluation from the beach was based on the former design of the house, which was larger than the current proposal. There were simulations done. They are attached to the revised initial study. From the beach, looking at the former design of the house, it would barely be visible from the viewpoint that was used on the beach. It would not block mountain views. It would not be substantially visible.
And
that would change over time, over a 75-year period, as the bluff eroded landward.
And this is which view elevation? I'm looking, at our draft EIR. So would you consider this to be the south elevation? This is page 3.7, figure 3.3-2. I just want to get the right view to correlate with your answer. So this is from the ocean, from the beach, looking up to the proposed home.
I'm sorry, what figure did you reference?
Well, I'm looking at page 3, I guess it would be 3-7, and it's figure 3.3-2. On this page, there's the north elevation, the south. 2 pages over, we have the east and the west. I just want to make sure, given your answer, I'm looking at the correct view and the correct elevation to understand. And as you're going, I'm sorry, did you find that page? And then
I did,
okay.
Thank you.
Related question.
As the bluff erodes landward, the edge of the bluff would become closer to the south elevation.
Okay.
That would become more visible,
right,
as the bluff retreats. However, being able to see the house in itself does not result in a significant environmental impact.
I'm thinking more of the subterranean engineering that's going to be required, and we've seen many projects over the 7 years I've been on this commission where that's what's proposed as necessary to secure and, quote, stabilize or restabilize a bluff top to ensure stability of the newly proposed built environment, home or otherwise. And so not just what the home looks like, what the silhouette of the home looks like from the beach and everything that's involved in that, but also as the bluff is anticipated to erode, do we have a sense of the subterranean engineering, the caissons, et cetera, that could then become
Commissioner Swartz, yes,
viewed,
yes, we do.
Mm-hmm. We don't have a visual sim in our package for that.
They would not be exposed, is the short answer. At the end of the 75-year period, at the anticipated rate of bluff retreat, and let me even clarify that a little bit. The rate of bluff retreat measured over time, which was in consideration of our existing climate conditions, was 1.02 inches a year. Then that was increased by 20% to accommodate for increased wave action as a result of climate change and a rise in sea level. And so it was based on that climate change related factor of safety, I'll call it, that the location of the top of Bluff at the end of a 75-year period would not have undermined the structure. It would be close to the structure, but it wouldn't undermine it like we saw in the picture that Mr. Franco showed. So none of the caissons would be exposed after that 75-year planning period.
Okay. Thank you then. But on the still on this topic of bluff stability or instability, I'm wondering, with us currently being in the longest drought on record and knowing that we have other areas of our city that are failing, so to speak, the natural environment is failing sort of from the inside out because of the drought, and then what's occurring resulting from that, I'm wondering if you or city staff have considered a new analysis or an updated analysis in this area based on the historic lack of water and whether or not it has it has or is likely to further the instability or progress in that direction. Does it help or hurt us? That's kind of my bottom line question there.
I think the answer to that would be it would be a net benefit to the project. Typically, increased moisture is an enemy of slope stability. You either have additional water running over the top of the bluff, eroding the top landward, or you saturate the slope material, which makes it heavier, and when it's heavier, it's more prone to failure.
And yet on the canyon side, I'll call it, what's being proposed is a newly vegetated area for the applicant where they've agreed to, I guess, and staff is recommending removal of quite a bit of existing vegetation. I guess it's viewed as non-native.
Correct.
To then newly plant native vegetation, which will require a fair amount of water, especially to establish the new plantings. And so, on the one hand, you're saying on the ocean side, on the bluff top, the drought could help us because we have an exceedingly dry bluff in that regard. But then on the canyon side, so now this logically doesn't make sense to me, but we're asking the applicant to agree to, I don't want to say destabilize, but move the earth, change the earth formation, take out what's existing there that already has deep roots simply because it's not native, and newly plant, which requires more water on the canyon side. Right?
Commissioner Swartz, I think anytime you can remove non-natives from the bluff, that's going to be a net benefit. Actually, a lot of times non-natives ice plant. I'm not certain there's ice plant on the slope, but it's a good example. The ice plant itself is very heavy and shallow rooted and will pull the slope down.
We certainly know that about ice plant. I mean, I viewed on Tuesday, and I've been to this site before, other non-natives. But I won't, pursue this too far. I just wanted to get your take.
I'll finish the response.
Okay. Yes.
Yes, the non-natives would be removed. There would be a requirement to plant natives, which are typically deep-rooted. That's how they survive summer drought, along with other adaptation mechanisms. They would be minimally watered for an establishment period, perhaps a year. That wouldn't be deep watering It would be in the root zones. The plants would be weaned off of that water, and they would then become self-sufficient.
Okay. Now, speaking of this, this top of canyon, I'm still not understanding. I've heard some answers. I think it was to Commissioner Higgins and Commissioner Thompson about this top of canyon. This is the first time in 7 years I recall hearing this term, so I'm still not clear as to the genesis of this, why we're using it. Is this now going to be precedent setting? It's just a real curiosity to me, and I'm not understanding the implications of including this in this draft DIR and the related project.
Commissioner Schwartz, I don't think there are any implications. That term was used at the advice of Coastal Commission staff to provide a distinction between the bottom of the creek that has a functional relationship to the hydrology and geomorphology of the creek, and what by zoning ordinance definition is the top of the bank. For purposes of evaluating impacts to the creek, that top of the bluff, for all intents and purposes, is the top of bank.
Okay, I'll get to that in my comments. Now, in terms of the Coastal Commission, I reviewed the email exchanges, plural, that occurred over in the year 2013 that staff provided us. And a couple of questions there. First, should I assume then that these comments back from Coastal Commission in 2013 would be a follow-on only to the 2012 first revised draft EIR? I mean, they couldn't have any information, obviously, subsequent to 2013 if this communication occurred in 2013. So we're talking today about not just historic conditions, but some fairly recent new analyses. And so I'm not seeing a more recent communication and position by the Coastal Commission staff on a number of questions that I think have been posed and probably will be posed also by some of my colleagues. A fresh analysis is what I'm getting at.
Commissioner Schwartz, so the 2013 are the most recent reports. After the 2012 hearing, we went back and were responding to comments, and new reports were prepared. And so the most recent are 2013. Like I said, there was a lawsuit that occurred. Things slowed down, but this 2013 report, although it's been a few years now, is fairly recent. Everything is up to date. These have been reviewed by Coastal Commission staff. We're very confident in its conclusions and such. So I would consider these completely up-to-date reports.
And then, Ms. Kennedy, I had asked you, there are 3 references in the Coastal Commission email to you, or actually that you echoed back to Coastal Commission staff, Mark Johnson and Melissa Ahrens. 3 topics. They were recommending a new biological assessment report. I'll just identify these and maybe you can respond. New biological assessment report. They thought that the canyon slope report needed to be clearer about development and foundation options. And then thirdly, they were also commenting about this, quote, factor of safety lines needing to be plotted on the site map. So could you speak to those 3 comments by the Coastal Commission?
Yes, Commissioner Schwartz. So I provided that email to you because there were questions about whether, in fact, the Coastal Commission has reviewed these reports. And we said in the staff report and the EIR that they have. So to provide evidence to you, I found this email. We've had lots of communication with Coastal Commission staff, phone calls. That reflected a summary of a telephone conversation. It was just a point in time, but it did state that they that Mark Johnson had reviewed the reports and he agreed with them, and that was the point of that. It does, though, bring up other issues. After that email, we followed up and did other things. So the biological assessment comment there, that was followed through with. We had a new updated report that's part of the EIR. You can see that. The question that staff had about the caissons and the foundation, that issue was resolved and included in the report. So it's in the report in EIR as well. And then about the factor of safety line, that was confusion, I believe, about some figures, and those were cleaned up later on. So they're really not any issues to concern yourself with, other than it's just everything was addressed after that. Yes.
I think I just have a couple more at this point. Let me go to your presentation, if I could, the PowerPoint slide. This is slide 28, Ms. Kennedy, from your PowerPoint. The slide is entitled Visual Aesthetics Mitigation Measures. Under mitigation measure, this is AES-2, the landscape plan. There's a reference to installing landscaping that will not exceed the height of the residence. And just in terms of our comments on the adequacy and completeness of this draft DIR, I'm wondering to what specificity maybe you could point me somewhere in the draft DIR, is this detailed, because this is particularly important regarding Coastal Act consistency, so that the landscaping does not tower up over this and then also visually impair, the public views in both directions. So how are we looking to ensure that compliance? They'll not exceed the height of the residence. You mean ever? It can't grow. It's going to be of a species that doesn't ever grow higher than whatever the height, the natural greatest height is of that species of plant material.
Commissioner Swartz, that is the intent. The proposed landscape plan, I think, has an oak tree or several oak trees proposed. Mm-hmm. Those could become very large.
Yes, they could,
and obscure views of the ocean. So the intent of the mitigation measure is that, as you stated, that landscaping would not exceed the roof line. That would be enforced like other items are enforced in the city. I imagine it would be a complaint basis.
I see. Okay. And then on slide 45, setback from creek. So here we're calling it setback from creek, and the first bullet point is setback from top of canyon. I heard the answer. It's just, I think using these different terms is, we're getting a little loose here. But setback from top of canyon slope would not allow any development. So this is what's confusing me. I'd like to see a site plan, if somebody could put up this site plan. Setback from top of canyon slope would not allow any development. Now I'm looking at our site plan, and I'm trying to understand. So this is the very first, this is sheet A.1, and if I can read this correctly, canyon top of slope looks like it goes, is that the green line? No, what line is that?
So the top of canyon slope is the green line
that we
yes.
see here on the
so that's
screen now?
Essentially the edge of the paved area on the project site.
The edge of the paved area.
Right. So when we went out to the site visit,
yes.
This is
so
where that curve
everything on the
be.
canyon side, whatever that's, east.
Right.
So in other words, what I'm seeing is everything to the east of this line is the cantilevered structure. Is that what you're saying?
That's
it doesn't
correct.
touch the ground. There's no development on the ground eastward
I
of
can
this
show you
line, which is canyon top of slope.
There is some. I'll show you the
yeah,
section.
That's the lower level. That's what I'm...
I'll have to go back a few slides to that.
Yeah. So you see what I'm doing? I'm trying to reconcile that first bullet on slide 45 with the actual site plan.
So here's the cross section.
So maybe you can help me.
You can see the slope. So portions of it are cantilevered, and portions are built into the slope itself.
Okay, and so where are we talking about setback from top of canyon slope would not allow any development? Can you, with the
I'll go back to
highlighter,
the other.
kind of just draw that line with your
Well, I
laser
added that
pointer?
to just, that's not in the EIR. Just
No,
to clarify
this is
that
where
if
I think we have a gap.
if
Yeah.
we're looking towards this as a potential top of bank that needs a 50-foot or 25-foot setback,
Correct, yeah.
right? So the yellow is 10, and
Say the yellow is 10, you mean that green line, or now you're talking about something else?
so the green is the top of canyon slope.
Correct.
The yellow is the 10-foot setback that is discussed in this report as a potential setback.
Oh, yeah, I see what you're saying. Yeah, the
So
other
that kind of
line,
gives you an idea where the 10 feet, if you were to add another 10 feet, another 5, say you're looking for a 25-foot setback from this location, that would be here. That essentially would not allow any development on the site. That's the point of that comment that I made on the slide, is that if you're looking at some setback from here, you'll see that it would really limit the amount of development area.
Would limit. So then help me understand what you want us to understand by this bullet point.
Right.
What's the takeaway here with that bullet point? Setback from top of canyon slope would not allow, does not allow, will not allow, would not allow any development when we're seeing development there.
If you were to, as a commission, say this is the top of canyon slope,
If we were to agree with
if you were to
that.
say that we want a setback from this area, that the building would be built, 10, 15, 25 feet away from that setback to provide another buffer, there's really limited area to do that.
Okay, now I'm understanding, but to me, that's a different proposition and a different question posed to the commission. Okay.
It's in response to some comments
I'll
about
move on and I'll let
a bluff setback or
our
a
chair
top of bank
wants to jump
setback.
in.
Yep, just so we're clear a little bit, a foundation, a standard foundation, grade beam or whatever foundation, not the caissons, if that was employed, is that really a distinction that we're trying to make? That if there was a setback and all you're doing was slab work, traditional slab on grade with a cut, that you'd have a problem building it because you would be so far in over the top of creek bank,
Top of canyon slope.
top of canyon slope, they wouldn't be able to build it. But now you're employing caissons, okay? So the caissons that you're employing, are any of those to the uphill side of the green line, or are they all on the downhill side? Meaning that there is some slab work that's being done on the downhill side of the green line.
Commissioner Campanella, I'll take a stab at that. As to your first point, the yellow line, you were correct that was if you were going to use a typical slab on grade foundation. For slope stability purposes, the building would have to be set back behind that yellow line.
Okay.
And I could get into the slopes.
No, I understand that. That's clear.
The building does extend over the green line. Mm-hmm. There would be caissons on the creek side of the green line.
Are there caissons on the uphill side of the green line as well?
Yes, there are.
Okay. So effectively, there is, by using caissons, you've affected some setback effectively from the green line because you're employing caissons on the uphill side to some degree and not a slab. Okay. So a setback that would be required for slab, you're satisfying that a little bit because you're not putting a slab on the directly on the uphill side of that green line. You're putting caissons as well.
You are avoiding potential slope stability impacts because there is unconsolidated fill that has been placed on the project site. If you were putting the slab on the unconsolidated fill, you could have issues. You would not have those slope stability impacts with the caissons going through the fill, which is about 4 to 5 feet in depth, to the competent Monterey Shale bedrock.
Okay, so I'm sorry, but what this points out, I think, in several questions that the rest of us may have, there's practicality based upon the site conditions and soils reports and topography and everything else that's being looked at relative to not causing a problem by building on that. Whereas there are different agencies and traditions and guidelines that require some type of setback without regard to what the actual infield conditions are. Is that correct? So when we have recommendations, I think we need to be clear, is it a recommendation based upon the actual site conditions, or is it a recommendation that's normally made no matter what the site conditions are relative to a setback?
Are we talking about geologic conditions or biologic conditions?
At this point, it's geologic, okay? Geological conditions.
Then, yes, the setback, the yellow line is a recommended setback based on the existing geologic conditions at the site.
Okay, and you've satisfied that by using the caissons rather than slab on grade?
Correct.
Okay, thank you.
I'm going to let one of my colleagues continue this if necessary. My last comment is back to this, the use of, the long-time use of this property. If we could get this slide up, which slide is it? Well, staff didn't put this slide up, but I think it was Mr. Franco's presentation. This is a view of the vacant parcel and stairs going down to the ocean, where the neighborhood, those in the neighborhood, have used this area to get down to the beach. Now, I'm trying to recall, because I was here in 2012 at the prior hearing, where there was a lot of discussion about the public's right to use, to continue to use the easement down the driveway, the property, and the stairs. I don't know if Ms. Ostranger wants to take a stab at this from a legal perspective, but I'm still not clear about whether or not there's I don't know if we call it a prescriptive right, or probably Ms. Peugeot can help me here, who's a Coastal Act expert and CEQA expert, but there's some kind of rights, as I recall we concluded in our last hearing, that the public has to continue to have access to this going down to the beach. Could you help us, Ms. Ostranger?
Chair Campanella, Commissioner Schwartz. That's something we could look at, but with regards to the public access and its environmental impact with the project, I don't think we can determine that right now. There may be prescriptive rights. I'll look into it. We'll take it and consider it as a comment. But
okay,
I don't have the history on the past prescriptive rights.
Well, there was
if any exist.
Yes. Okay. Well, I think that's unfortunate, because here we are 4 years hence from the last hearing. There was quite a bit of conversation and question about that, and I really would have hoped that we would have a definitive answer about that,
Commissioner
so that we
Schwartz?
could look at that vis-a-vis the adequacy and completeness of this second draft DIR and the proposed built environment that we're looking at, and whether or not it satisfies, let's say, if there is a legal obligation by the property owner to provide safe access down the driveway along the property to these stairs down to the beach, since it's been there for many decades and the public's been using it for many decades. But we can just maybe note that, since we're just doing comments today. I can come back and just give you that as a comment, or you can take this line of questioning and assume it's going to be a comment.
Commissioner Schwartz, I'd like
Yes,
to
please,
address
Ms.
the
Kennedy.
public access. So we don't have any evidence that this is a public access path down the bluff. There is an easement for some neighbors to use a part of that driveway to access the path down the bluff, but there's no recorded document that shows that it's public access. And there's a note on one of the plans, a site plan, I believe. It's a 3-foot wide access easement for a number of neighbors. I'm not sure which ones that that are allowed to use that. So I think it's pretty clear based on what we have that we have no evidence.
There is some.
There's no public access, but there is access for other people in the neighborhood to use it.
Commissioner Schwartz, with that information, if there's been no public easement perfected, it sounds like there may be some private easements that residents own, but if there hasn't been a perfected public easement, then it would be hard for the EIR to consider that.
Okay, well, I'll come back during my comments to that. I think I'm going to leave it at there. No, I'm sorry, one last question. So back to page 3-7, figure 3.3-2, I'm seeing a lawn, a very lush green lawn here. I know that looks very pretty, but January 1, things are going to change in watering natural turf in the city of Santa Barbara. So I'm looking at this lawn and the proposed home, and I'm wondering if this is to scale, accurate and to scale in terms of the development envelope, vis-a-vis what we've been talking about regarding bluff top and setbacks from on the south elevation, from the ocean bluff top. I had referenced this same view when we were talking earlier. Because I don't know, this says 2012, so, 4 years ago, this was the view, the simulation and the proposed, I guess, landscaping, but we're now at a different point in time.
Commissioner Schwartz, if I may, I'd direct you to figure 3.3-8, which is the landscaping plan.
Okay, let me get to that one. What page? Oh, there we go. Oh, that's not, well.
That would be the last page of section 3.
So you don't have like a artistic rendering that I could see? This is 3.3-8 is?
The landscape plan. There's actually very minimal landscaping as you would commonly think of landscaping. But what I wanted to point out here, and I think what the green simulation is depicting, is the dark gray area to the east and the south of the project site. And that's the proposed 8,000 square foot restoration area. So that's the area that would be planted with natives.
So then what do I see? I don't know that we have this in a slide. So then there's this white area. Okay, so we have this dark gray area that you've just said is the revegetated area.
Right.
And we see, the building envelope. And I don't know if this is a deck or solar. Anyway, I think a deck proposed. What's the white area that's neither the permeable paved area nor the vegetated area? What is this supposed to be? I don't know how to refer to it because we don't have a slide per se, right in here. What's that if it's not landscaped? This is the figure you just referred me to, 3.3-8. I'm trying to see if there's any fine print that may address it, but I don't see. Oh, I get a magnifying glass from my colleague. Wow. No, I don't. Thank you, Ms. Peugeot. But I'm looking at this. Well, no, that doesn't. I don't think that points it. Earthen drainage, swale, and erosion resistant landscape ground cover shall be seeds critical coastal mix on. Okay. I don't think that's really helping. So you don't know what that kind of big white area is that's on this black and white one-dimensional?
I would turn to the architect to look at that. In looking at the site plan, nothing is shown there.
Right.
That could remain in its existing condition, although I don't know if
it's paved. There's asphalt there now.
Right. I don't. If that is their intent, I don't
Mr. Piker,
know.
do you have any information for us? And then that's my last question, Mr. Chair.
Chair, Commissioner Schwartz. Yeah. So, should really be looking at the landscape plan, which is in the set of
Let's go to plan.
the landscape plan. Yeah. Okay. In any event.
I know it's 2012. I really want
No,
to.
Piker, thank you.
Yeah, sorry. There's no.
Oh, I'm sorry, Mr.
No
Piker,
lawn
yes?
or anything of that nature is being proposed anywhere. It's really just consisting of the area in which restorative landscaping is going to be placed and the invasive species removed, et cetera. And that little area that is next to where the driveway is, a portion of that. If there's asphalt paving there, it will be removed, and it will be landscaped with similar kind of landscape features. I don't have the landscape plan in front of me. It's in our larger scale set of plans.
I see.
can kind of examine that, come back to it if you like. But,
Okay.
The intent here is just simply to do the non-invasive landscape for the entire site.
Well, I know, Mr. Parker, you can appreciate that we and even the Coastal Commission has become much more sensitive to landscape bluff tops. We've evolved our policies in the city, as you know, over time. And so we're looking to be very sensitive and careful about allowances with landscaping on our coastal bluff tops. So I really wanted to spend some time with that. And sorry, we don't have an answer for that right now. Thank you, Mr. Chair.
Okay. Commissioner Peugeot.
Thank you. I'll go through whatever remaining questions I have that haven't already been covered, much of which has, and I appreciate all those discussions. I think it's been great. So my first question, though, is really the type of EIR that we are reviewing. So I read, and I want to just get confirmation that this is a focused EIR. Is that right? Even though it's been revised and it's being revised, and I see Ms. Shelton in the audience, and also we have our city attorney. I don't know if one of them wants to answer this, but my understanding is that it's a focused EIR, which is why we don't see full discussion of each of the check sheet items in the document itself, but the initial studies attached. And so the way I've been looking at it is combining the expanded discussions in the front of the document with the review of the revised initial study in trying to piece together my understanding of the environmental review. Is that the right way to do it? And is there comment available on not only the main version of the expanded document, but also on the revised initial study as kind of supplementing the rest of the discussion topics?
Yes, Mr. Chair and Commission, that is pretty much everything you said is correct. When we do an initial study and we identify potential significant impact, but we identify mitigation and no further analysis is really needed, when we're doing scoping for the EIR, we do tend to just focus on those things that are either unknown, potentially significant, but we need more analysis to really nail down what is the mitigation and the residual impact, and we really just focus the EIR. And so, yes, you would look at all of the impacts of the project. You would look at items that are in the initial study as well as in the EIR, and it's fine if you want to have comments on any of those items, but the primary focus clearly is the EIR, additional EIR analysis that was done subsequent to the initial study, revised initial study. But we did, in this version of the EIR, have an expanded discussion in the EIR of impacts found not to be significant. And we had, I think Kathy went through all of the initial study issues where there were mitigation measures as well. And obviously through the long period for this revised process, updated information on some of those items that were in the initial study, such as the biological updates, were done. And so it is a focused EIR, and we can take comments on any of the issues and provide written responses.
Okay, and those written responses will be the entirety of the responses, even if they were topics that were only showing up in the initial study?
That will be fine.
Great. Okay, thank you. I have one follow-up question about that before you leave your chair, or maybe, did you have any supplement to that?
I was just going to add, Chair, Commissioner Peugeot, as Ms. Shelton said, you can comment on initial studies, but the focus of today is to take comment on the draft EIR, second revised draft EIR. So
that's starting to confuse me. I understood it a little better with Ms. Shelton's answer, because some of the comments that we have, some of the questions that we've had, and some of the comments that I assume we're going to have are to things that are primarily addressed in the initial study, even if some of the class 3 topics and all were generally discussed in the main part of the document. So I'm hoping that our comments can be more broad than just the focus part of the EIR.
Can I offer a suggestion, Commissioner Peugeot, is perhaps we stick with the focused one for the moment and then come back to
Well, I think we've already gone way beyond that in our questions so far.
Mr. Chair, I think it's fine if we get comments on the environmental analysis. The initial study is one of the exhibits to the EIR, so it is part of the EIR. And I completely agree, though, with the city attorney that the focus at this point, because we did do the initial study and we have kept it updated as we've gone along, but the focus of, based on the scoping that was done at the Planning Commission and so forth, was the issues that are in the main body of the EIR, the visual and the geotechnical and so forth. So I'm fine to get comments on, because the idea of this document is that we do have sufficient environmental information to the decision makers and the public about the impacts of the project. So.
Okay. Well, I'm going to go through my questions and we'll see where they lie. But anyway, to me, like you said, the exhibits, the whole of the document is what I'm interested in. Okay. So my next question, I just want to get clarification for this because I believe that I do understand when you have a project description for an environmental document, and it's that project description that you're analyzing in terms of the impacts. Can someone just state clearly for me whether or not there is a debate about the legality of the parcel? I don't know how that relates to our job in commenting on a project description that isn't approved as a project yet, but it's being analyzed for potential impacts. I mean, I can give you my point of view, but I'd rather hear it from our expert staff or the city attorney. It seems like it's the way the project is described and the impacts that we're interested in.
Ms. Shelton can correct me if I'm wrong, but we're looking at this in the EIR is evaluating this as if, and it should be a legal lot. It's my understanding, not having the significant history that Mr. Vinson does, but that this is now being considered a legal lot subject to the certificate of compliance.
So as of today, we're assuming that it's a legal lot, and if there's if there's concern about that, is that a CEQA comment, or is that something that needs to be dealt with somehow else?
Mr. Chair, I would suggest that we really should just look at, this is the project description. We are evaluating it. Decisions were made to accept an application and to process it, and we are evaluating this project. To the extent that there is new comments or new issues raised about legal issues, those will be looked at, but it is sort of apart from just what are the impacts of the project as proposed. So I really suggest that that's the intent of the hearing today.
And we need to move forward with that discussion, right?
Yes,
okay.
Because there will be subsequent hearings where we can on the project where some of these other issues can be looked at.
Okay. All right. So I'm going through the rest of my questions really just using the PowerPoint slides as sort of a guide in the order they come up. So the first one is under visual aesthetics, and this was brought up as a question before about and I think Commissioner Schwartz did, about the height of the limitation on the height of vegetation and trees and whatnot. But my question is that topic, but with slightly different angle on it. I was just reading it and just trying to, it says the height, I think it says the height of the vegetation can be no taller than the height of the structure. But I guess what I don't understand about that is one portion of the structure is like 25 feet on the downslope. So does that mean any vegetation can be 25 feet from where it's planted, or does it mean it can't rise over the roof line of the structure, which to me are two different heights?
Mr. Chair and Commission, I think it's a good comment that should be clarified, and so we should be looking at that and making maybe some refinements to the language and response as part of the response to comments.
Okay, take a look at what that would mean and then respond to it, because right now I don't know which is it. Okay.
Can I make another comment about that?
Yeah.
It is relating to the degrading the view. So the point of this is that you have a house proposed in a certain area, and that you don't want the landscaping growing up between the public view area and the home. So that view from La Mesa Park or the bridge would not be degraded if we kept the landscaping down. So that's the point of it. It's from a view from a distance looking towards the project site. So that's the,
and I do
potential
understand
impact.
the context of that. I just not clear whether that means it has to be it's still roof line or anywhere 25 feet, because anyway, I think you'll need to figure that out. Okay. My next question, it goes back to the idea of potentially, I think it was Mr. Franco said there might be 100-foot caissons, or someone said that. First of all, I guess I assume that is the case, although I don't know if I heard anybody verify that they actually will be necessarily 100 feet, those caissons. But say if they were, the question that it brings to mind is somewhere in the document. Does it discuss what, not in terms of visual, but in terms of stability and disturbance? Is there a discussion of how those caissons would be drilled and stabilized so that it wouldn't do any other disruption to the bluff or the slope?
Again, possibly, Steve, you might want to talk about what's in there now, but I think that's an issue that would benefit, again, from a more detailed written response to comment to clarify. There are a lot of regulations as a part of the building and safety building permit process. So there are some of these things that are sort of given, but they need to be perhaps just clarified and explained. And, this type of thing requires under the building code that there be a qualified geotechnical person overseeing all of that as well. And the more detailed grading plans would have phasing and particular criteria, performance criteria that are used to avoid sort of the temporary potential issues, and there might be monitoring as well, devices placed to just confirm that. So there are processes, but I think we could augment the discussion as part of the response to comments just to clarify that.
Great. Okay, thank you. My next question, I think I know the answer, but I would like to hear it, is going back to the top of bank line. I'll have a comment later about that, but my question is generally, we saw one slide that showed a prior plan where it pointed out, if you were really closely reading the plan, of where the top of bank was delineated on a prior plan. But where is that in the draft EIR? Is there, I didn't see any discussion or description. Maybe I missed an exhibit or something that showed the top of bank, not the top of slope, but I'm talking now about top of bank.
Commissioner Peugeot, so you're talking the lower.
Correct.
That delineation of that bank is no longer really part of the analysis.
Okay, well, I guess you'll find out later that I don't necessarily agree with that statement, but I guess the answer is it's not in the current draft EIR. Is that right?
I'm sorry, could you repeat?
The diagram or the location of top of bank is not currently in the draft EIR.
It is. It's in the 2002, I think that's the date, the original biologic study done by Tierney. That's where that original delineation occurred.
So it's in one of the attachments, but not in the text.
Correct.
Okay, thank you. Because I think we're just doing comments now. So, okay, so my next question, I think this is discussed in the geologic hazards section, I believe. There's discussion of limiting irrigation use, and we've touched on that before. Too much water loading into the soil could have some potential effect on the erosion and potentially slope. But when I think it talks about limiting, I think one of the mitigation measures perhaps talks about limiting irrigation use. If you could just clarify for me, is that just referencing like the 1 or 2 year need of temporary irrigation before the plants are established, or what's included in limiting irrigation? Drought tolerant, low water use. What was assumed there?
I'm not certain precisely which mitigation measure you're referring to. There could be, in terms of slope stability, which would be more of a general, the things you just mentioned. Drought tolerant landscaping, efficient. We're not going to have rainbirds out there. It would be drip, minimizing water application to the slope.
For example, I was reading the email we had distributed to us recently that came from the Creeks Division, and it had a lot of detail on some of the mitigation measures and the requirements for low water use plants and drought tolerant landscaping, and it had a lot of information in it about certain like monitoring and reporting. When I looked at the mitigation measures, I didn't really see all of those incorporated, but maybe I missed something on that. And also, I'm not really sure, drought tolerance required, but also it says, I think something like drought tolerant and low water use plants, but I'm not sure in this case, is there need for extra attention to maybe very low water use or only limiting it to natives? I don't quite understand how those things get us to that protection we need for preventing overwatering or oversaturating of the soil.
Mr. Chair and Commission, there is, as you know, in the city, a fairly detailed process for the follow-on work for the final version of the restoration plan and landscape plan and design review approval, Creeks Division approval. And you're right, we have some initial direction and comments both in the EIR but also from the Creeks Division as a part of their application DART review comments. I think it's a good idea to augment, as part of the response to comments, some more detail on those issues. I agree that on any of these top of bluff areas, it's a good idea to be very clear about the watering issue. And so I think we can do that as part of the response to comments.
Okay, thank you. My next comment, and just clarify, you did discuss this, Ms. Kennedy, in your presentation, or I'm not sure, actually, maybe it was even the applicants that showed the car being able to get through the site. I know that transportation has more or less signed off that certain vehicles could make it through, but could you just go over that again? If it's 7.5 feet, is that because average car widths are less than 7.5, or what was the basis for transportation signing off on that as being, minimally adequate to get a vehicle through there?
Commissioner
Through the
Peugeot,
pinch point, I
in the
guess.
staff report, I summarized what transportation planning had told us, and that it would. I'll just read this here. A majority of passenger vehicles could access the site, so they could make it through that 7.5 foot.
But is that because they wouldn't need to encroach because the and the sides of the vehicle would be less than 7.5 feet wide? Is that
why? The standard
why?
design vehicle, they say, is 5 feet 10 inches wide. The standard vehicle is 5'10", so
Okay.
this is 7.5, so it would fit. They need to be aware, of course, that larger vehicles would not be able to, that are wider than that. But he also mentioned a Hummer, which is a large car,
Right, I think
is 7 feet 1 inch wide.
Yeah,
so that would barely.
That's the very far end of the other spectrum.
So it gives you an idea of the number
What about
that
construction vehicles?
Right.
Get onto the site?
Again, anything under 7.5 feet wide, that would be a something that the applicant owner needs to look into that. We have not looked at the size of
I'm not a construction
vehicles.
expert, but do you think there are such things that can get in there to do the caissons and all of that with it?
I believe it will be challenging, but that's up to the applicant to determine and
So
construction
that's all
team.
we know right now. Is
Right.
that it? Okay.
That's right.
And I just want to clarify, so my understanding so far is that what we do know about the 3-foot easement and is that it's most likely, or it is, I guess I'd like clarification on either of those, that those are by private easement. And when you say the neighbors, are you talking about that the set of neighbors that access that same driveway easement, or is it a broader area where those easements might exist? And as you answer that, the easement that I think is shown to us, I don't see it unless I didn't notice carefully enough. Does it go down the face of the bluff, or does it stop at the top of the bluff? I don't know what to point to.
Campanella, Commissioner Peugeot.
Yes, thank you.
The project description is setting forth the actual easements that you're looking at and the EIR is considering, so that's what we're considering here, and that's where the comments and questions are going to. I don't know if that answers your question.
Well, does the easement extend down the face of the bluff all the way to the beach? I see the staircase, but is that the actual legal easement as well? Do we know that?
We can check on that to clarify it. It does show 3 feet on the western side of the property.
But what we have now doesn't show it going down to the bottom, right?
We can clarify that and make sure. But I
Okay.
think the issue overall is that it's not public, but it is neighbors, I think, and I can clarify this as well, that use that driveway otherwise.
Okay,
So-
because I imagine that information would be in the applicant's title report.
Probably it's not that straightforward as typical
Okay.
projects
All right.
as far as that
All right.
type of thing.
Hopefully
so it's
we
not
get
that
some
easily
additional
defined.
clarification. Okay, thank you. Okay, that's it. That's all my questions. Thank you.
Okay, Commissioner Lodge.
Thank you, Mr. Chair. On page 3-5 of the draft EIR, under 3.3.2, it says other building features include the use of a green or vegetated roof. I share the same concerns Commissioner Thompson had on that part. And then it goes on to say, and solar panels along the eastern and southern edges of the roof. I couldn't tell if those were included in the photo sims or not. But that should be, if they are going to be visible. I guess that's more of a.
Mr. Chair and Commission, we want to check on that and clarify, just to be sure.
Okay. And then on page 4-1, the last sentence begins, wooden stairs located near the southwestern corner of the proposed residence development site lead to the trail, which switches back across the southern exposure of the bluff face and terminates at the beach below. And the figure 3.3-8 and some of the others indicate the different contour lines for the trail. And so I think it should be clarified just what the situation of the access is for that. Then it looks as if we've got three different top ofs that we're looking at. There's the coastal bluff. I think I understand that one. But then slide 44 says top of bank versus top of canyon slope. Second paragraph, top of canyon slope location was determined using the top of bank definition in city ordinance for Mission Creek, intersection of general plane of slope with upper generally level ground. And that suggests to me that it's what you are, well, I'm confused. Is that the top of bank for the creek, or is that top of the back canyon slope? And this was the language as I understand it here in the slide, what's on the slide, would be the top of the canyon slope. 44. This sort of goes all the way down from up at the top to the creek itself.
I'd like to just comment briefly. You may or may not recall back in 2012 we talked about the top of bank a little bit. There was concern about whether that was a top of bank or not. We tried to actually help by calling this the top of canyon slope to really have a point that we can, area that we can point to and discuss, the cantilevering over that and where the building is located. So I'm sorry that's confusing people, but the intention was to actually make it a little bit more straightforward.
You have a slide that show where you can show where the top of bank for the creek is. That seems to be the third.
Commissioner Lodge, are you referring to a functional top of bank or a zoning ordinance top of bank?
Well, we have references here in the slides, to the ordinance, and then we're being told that, well, no, the creek itself is way down there, close to where would be water if we ever have water in our creeks again.
Mr. Chair and Commission, I did just want to make a point about the ordinance because there has been a long practice and evolution of how that is applied because of the fact that the ordinance, as it's currently written, applies to Mission Creek. But we have typically used it when it's appropriate. But in fact, doing these analyses on various different creeks throughout the area is more of a case-by-case basis. In this case, we're really focusing on environmental impacts in this particular document. And that part of the ordinance doesn't officially apply on this property because it's not part of Mission Creek. But we do have our practices where we're looking at that, and there was interest in understanding that information. In this case, the EIR analysis using that lower top of creek bank that is more the sort of actual geomorphological or hydrological connection to the creek, where you're looking at impacts on that basis. That was what a lot of these reports were doing, but we have also now identified this top of canyon slope, which has other interest for this project based on how the city is going to look case by case at this project, this set of conditions, physical conditions, and what would be an appropriate location for the development setback from these various lines in order to address biological issues and geotechnical issues. I think that based on the comments from pretty much all of the commissioners about the fact that this is still not clear on these two different lines, that it would be a good idea for us to provide, as part of the response to comments, some further clarification of those lines and how they relate to environmental analysis and policy consistency and so forth.
Okay, thank you. I would agree that would be a good idea. Slide 40 says Bio 5 requires streambed alteration agreement from California Department of Fish and Wildlife. Why is that in there? If there's, what was just said sounds like, well, the creek's way down there and it's really not part of a concern. But then there's this condition.
Correct. Commissioner Lodge, there is a very small component of the project. Their drainage plan will convey water directly to the creek. There would be some disturbance of the creek bank, the hydrological creek bank, that will require a stream bed alteration agreement.
Okay, let's see. Okay, those are my questions. Thank you.
Okay, just picking up, if I can, on the stream bed alteration, there's going to be the outflow going into the creek, but you'd also be crossing public property, correct? In order to, it's not all private property to get to the creek, is it?
The drain line would be on the project site.
All the way to the creek?
Yes.
Okay, it's all part. Okay, it's all part of it. Okay, I got that. And then I think everybody's covered geology and bio. I've got a question on the exterior. Has the exterior of the building itself been approved by Single Family Design Board? Conceptually, or
there's been no approval. They have gone to SFDB for comments. No approvals.
Okay, and the comments have been favorable, or?
They have been overall, yes. I don't have them in front of me. I'm not sure if they're, I think they might be attached.
Okay. I was just, not being an architect, but, as far as, the requirements, neutral or natural earth tones with surrounding topo or vegetation, I'm just wondering if this color exterior, if this color exterior makes it more pronounced from a view standpoint, even though it's natural, versus the long view to the ocean and as well as the landscaping that's going to surround it. I guess I would make that comment if it hasn't been. Right now, when you look at these sims, it stands out. There's stone and it's beautiful and glass, but it doesn't blend in to me with the topography. I mean, we're not talking Southwest. I mean, you have ocean background and the landscaping. So I would just throw that out, that maybe there may be some other softening that could be done that might allow this to be blended in a little more with the natural surroundings. And again, maybe they've already approved this, but I would just offer that suggestion, just based on what I see on the photo sims while waiting for the trees to get mature after clearing has been done. So that's everything else has pretty well been covered, I think. My notes. Okay. Do we think we can roll into comments, or do we need to take one more question? Okay. Well, let me ask the question relative to after you ask that question, and Mr. Higgins' question. Will we be able to roll into comments? Do you think, or are we going to need a break of some type? Okay. Mr. Higgins?
No questions. Just I was going to roll into comments.
Okay. Thank you. Commissioner Schwartz, you had one more question.
Yes, just a clarifying question back to slide 40 and this issue of the streambed alteration agreement. When we were at the site, I asked about the property, which is most of the canyon and the creek, and am I correct that I was told that it's the Coast Guard property, it's U.S. government, right? So I'm not, and when we put out this our second revised draft EIR, the Coast Guard did not respond. That we had no response from the government pertaining to anything in our draft EIR, and yet I'm not understanding then the nexus between them owning the property and now us engaging the California Department of Fish and Wildlife, and how is the property owner, which is the U.S. government, well, specifically the Coast Guard, not somehow involved in this mitigation measure and approving it if we're talking about some of the water being funneled down to and onto their property?
Commissioner Schwartz,
No?
it would not be discharged onto their property. The discharge is on the project site.
And it just vaporizes onto, it just evaporates on right there on the one property and doesn't go down into the Coast Guard property at all. That's what you're saying?
There would be, well, a couple of factors. There would be erosion control at the discharge location, but I think more importantly, with the city's requirements, state requirements, there would not be an increase in flow because of requirements for on-site retention. So the project is not going to substantially increase discharges into the creek. And I think the drainage study actually shows that they're, under certain flow conditions, it would be decreased.
I was just wondering how we have the city, we have the California Department of Fish and Wildlife, and we have the Coast Guard or the U.S. government, and why all three were not collaborating on how to manage these contiguous natural resource, and what will flow downhill no matter what we engineer was confusing and a little baffling to me. But I understand your answer, and so thank you for that. Thank you, Mr. Chair.
Okay, if there's no other questions, we'll go to comments. Commissioner Higgins.
Thank you, Mr. Chair. So I appreciate Commissioner Peugeot's question about the nature of the document, whether or not it's focused or other, and Ms. Shelton's response was helpful. So I just want to recommend that we take the section in the initial study for plans and policy discussion and bring that forward into the body of the document next time we see it, with respect to a couple things: access, vehicular access, and I'd just like to see a little bit more information from transportation staff as to how that pinch point is going to be consistent with their standards, and whether or not they have any other further mitigation or design considerations. And with that, I'd like to see a little bit more information about the neighbor's point with respect to removing some structures in that easement. Also, some discussion in that section about the Subdivision Map Act. Without getting into it, and I'm not asking the question now, but the allegation was that the original lot was conditioned to have a 15-foot wide easement or access easement, and it doesn't now. So just can we flesh that out in that particular section or another section? And then I just, obviously we need some help with the slope definitions, and I can appreciate that we're talking about scientific terms that relate to environmental effects, and then we're talking about regulatory terms. So maybe we can keep in that particular section, the EIR, that talks about policy consistency, a quick and succinct discussion as to whether or not those terms, those scientific terms, are come with it a regulatory standard at the local level and the coastal level, and if you have to, maybe the state level for the streambed alteration agreement, although maybe that's too much. I appreciate the commenter's comment about whether or not the city has adequately addressed alternatives. Rhetorical question, but if the neighborhood, if the opposition wants to suggest other feasible alternatives in terms of specific home size or location, that they should do that, and then I would look for that comment in your written letter to us, and that staff evaluate that. But my sense here is that that may be just a chasing our tail, because it's obvious that the opposition, in my mind, doesn't want anything there. So color commentary only, and I would like to get some clarification too on the public, or the nature of the existing pedestrian easement, prescriptive or otherwise, and whether or not there's any likelihood that the Coastal Commission will exact a public easement out of the CDP. And if that's a possibility, we should evaluate whether or not that's going to have an environmental effect on the slope. I would also like to see some information in the document when it returns with respect to construction access, types of vehicles that can or can't be used, whether or not any cranes will be needed. I don't think you're going to get any cranes back there through the pinch point, but that doesn't mean you can't get them closer than you would otherwise. So just some information about the construction process. And those are my comments.
Commissioner Lodge.
Thank you, Mr. Chair. I don't really have anything to add to what Commissioner Higgins just said, and my other comments were sort of wrapped up in my questions. So, no, I do not have anything to add.
Okay, thank you. Commissioner Thompson.
Okay, thank you. I guess you can tell from my questions before that I think that the depiction of the coastal bluff top of Bluff is erroneous, where it goes down the hill by the very English definition of top. It can't be proceeding down the hill. So I think that really needs to be clarified. And really, you show this top of canyon ending about 8 feet from where you show the top of Bluff going downhill. It would make eminently more sense for the top of Bluff to just connect to the top of canyon. The issue about top of canyon versus top of bank for the creek does need to be clarified a lot more, like Commissioner Higgins said. When you look at the topographic map, there is no break in the embankment going down to the creek. So there's not a really much of a justification to show a different top of creek bank and call something else the top of canyon. I would remind you that the staff required and this commission approved an almost 50-foot top of bank for a project that was just for a concrete drainage channel that went between a city street and a federal highway. So to say that we can build beyond the top of this creek bank in this environmental document doesn't make a lot of consistent sense. So that needs to be fleshed out quite a bit more if this is what you're planning to do. And I think that, as I mentioned before, the view analysis from the ocean, as we require on all the other coastal permits, needs to be included here in the environmental document. Those are my comments.
Thank you. Commissioner Schwartz.
Thank you, Mr. Chair. Well, when I look at page 1 of the staff report, I know that staff, has wanted us to focus on the potentially significant project impacts in two areas, visual aesthetics and geology. But I have to say, since I was here in 2012, and so from 2012 to now, I have the full record of what's been submitted to the city thus far. I think there are outstanding issues, and you've heard a number of them from the commission today, that fall outside of visual aesthetics and geology, or maybe are tangentially related, shall I say, that have not been adequately vetted. There are the issues of, and some of my fellow commissioners have mentioned that, but particularly the vehicular and pedestrian access and how that relates to the acceptable width of the easement, the driveway, again, going back to transportation planning and the fire department, make sure that there is comprehensive analysis done in that regard. Let me mention the geotechnical studies, and again, this goes back to our last hearing in 2012. I remain skeptical of the data that's been produced regarding the stability, the slope stability, the bluff stability in this area of the mesa. We've had quite a number of projects over the years, applications, in which there have been an array of geotechnical experts and their reports that have been submitted, and there doesn't seem to be alignment. So, of course, therein always lies the challenge as to who do we use as the definitive reference and their data for making our decisions. However, with the history of slides on the mesa, especially in this specific area of the mesa, I'm still not confident that we have full history before us to properly analyze the likelihood of additional slide in this area. Now, that's separate from whether or not the property owner has the right to develop on this property. That's separate from that. I just don't know if our geotechnical studies are adequate and complete in that regard. I'll leave it to the majority of my colleagues when it comes back for final, I suppose, and whichever other decision-making body needs to view this as to whether or not this term, top of canyon, I have to keep reminding myself of the term, canyon top of slope. It's even confusing to remember the exact phrase. I don't know why we're introducing it. I think it's problematic to not have, to utilize a term, a geologic term that also has policy implications, that isn't incorporated into other major policy documents like the Coastal Act, and that's why I was trying to find out if I've just overlooked something in us using both these terms. Now, that leads me to also say, if possible, my preference would be, whenever this comes back as a final, a more current, written opinion from the Coastal Commission on all of the updated information. And lastly, regarding this pedestrian access, public access along this driveway, along the easement, onto this property, and to the stairs below, again, much conversation occurred in 2012. I didn't bring all of my binders from that hearing from back then. I apologize, because the public submitted, the neighbors submitted a variety of historic and legal documents, so I hope our city attorney's office has been provided with that should have been resolved today. And so it's frustrating to me that we went through all of this in 2012 specifically to that. Why does that matter? Not just from a legal perspective, but it may affect decisions made as to the width of the driveway, the development envelope, the landscaping. What else has to be provided for safe access to the public to continue this pedestrian access to the bluff top and stairs down to the beach? That was really critical, or that was a critical factor in 2012 that I don't think has been resolved. So I'm frustrated that it's not in our documents today. It's like yet another item to analyze or to resolve. And I wish we could have just been able to put that to bed today, but it sounds like that still needs to be incorporated. So little bit more to do. Appreciate Commissioner Higgins' identification of the list that is largely my list in addition to separate from what I've just provided you. So I know this is a huge undertaking. I'm sure it's very frustrating for the property owner who's here today and for some of the neighbors. But let me just say that eyes wide open, buying a property on the bluff top, any bluff top in the coastal zone in California, is fraught with a lot of complications. So should it have taken less time? I don't know, but we have to be really careful about what we develop and how we develop on the coastal bluff tops. And quite frankly, the policies are evolving too. I know the Coastal Commission's position on development on bluff tops is evolving. So hopefully we'll come to the right balance of policy making and decisions. I look forward, if I'm still on the commission at the time, to seeing the final return to us. Thank you. One never knows. Thank you.
Okay, Commissioner Pujo.
Thank you. Okay, here are my comments. You'll see a lot of overlap with some of the comments fellow commissioners have already made. The first comment I have, I don't think has been brought up before, but I believe that it would also behoove us to have an explanation in the introductory portions of the document that talk about not only the fact that it's a focused EIR and whatnot, but this project, as we know, has been in the environmental review phase for like 14 years, plus or minus. And I certainly don't want to see it go another 14 years or 10 years or even 5 years or 3 years. I hope we get it done. I mean, that's our goal, is to get this done and finished so we can move on to the permit phase. But I do think that there should be some discussion of the ability to continue to use the same baseline, or what is the baseline that we're looking at in this document. The project's been revised, so maybe that changes that. I don't know, but I think there should be some description of the baseline and its current validity, including all the work and documentation that's provided. And I think that if we get this done in short order, that's great. But I do fear that as time goes on and as we don't incorporate, say, all the comments and try to come to a complete documentation, there'll be a point where maybe the baseline doesn't work anymore, and I hope that doesn't happen, because I think we really need to move forward. And I want to recognize the incredible amount of work and studies that have taken place to date. And Commissioner Schwartz mentioned, well, it's a difficult site. So I agree with that, particularly on these bluff top sites. But I do at this, and so I know what it took to get here, but I do also want to recognize that the comments that I have are comments to an environmental document, but they're in no way intended to mean that the documentation that's provided in the past hasn't been an extraordinary effort. I just want to mention that. So to my comments, I mentioned the baseline. The next comment I would like to make is on the visual analysis. The focus has been on the Lighthouse Bridge, the canyon, and Mesa Park. I, along with Commissioner Addison, feel that there's a deficiency in the discussion about the views from the beach and the ocean. I believe that's what Commissioner Thompson was saying. But the initial study does include some older photographs or visual simulations from the beach. they're very hard to read, and they don't really give me a clear picture from looking at the initial study of what that potential impact or lack of impact is from the beach. And so my comment would be bring that forward to the main part of the document. As a matter of fact, take it out of a slight mention in other viewpoints or visual view sheds or something that you have in there, and give it its own section in the draft and talk about views from the beach, and either give us the colored, better resolution copies of those visual simulations or produce new ones that show that the views are limited. Because I believe the document does say that you can potentially see the structure from the beach, but I want to know what is it really that we see, and it's not clear. So that's that comment. And also, Ms. Shelton, thank you very much for your comments earlier to some of my questions. So I do want to make sure that there's some clarification. Are we talking about vegetation that projects over the roof line or is 25 feet or lower? There's a difference, I think, in the result in that. And again, thank you, Ms. Shelton, earlier for your offer to add more information about the 100-foot caissons and how that would affect the stability. And moving on, top of bank. Okay, here's my comment on top of bank. Similar comments, but there's a difference here. The policy section of the draft EIR includes policy 610, which is a policy related to setbacks from a creek and the top of bank of the creek. In order to know that we meet consistency with that policy, we need to know where that top of bank is. So that, to me, is my reason why I think that we need to include top of bank discussion and diagram in the document. I understand, Mr. Rodriguez, your geologic perspective, and I totally respect that. And I also respect the fact that you have incorporated a second setback. I don't think it's one or the other. I think the clarification is important, and the discussion of policy consistency for that one particular policy on top of bank is important. And I think, to me, that settles it. I do think, and thank you again, Ms. Shelton, for mentioning that you could maybe go into more detail about what are those measures that will be required to assure that the landscaping and irrigation on the property will not exacerbate the conditions, so that we fully mitigate that impact regarding potential saturation of the soils on the site. And so my comment would be, please do that. And also, I want to mention in the comments, too, that in terms of monitoring for that, I think it's very important to include not only for the creek restoration portion, but for the watering portion as well, monitoring and maintenance and reporting, something along the lines of what's included in the Creeks Division's letter, so that we know that this is going to carry out over time, so it's not just a fixed one-time action, because that's an operational issue, and we need to protect from that operational practice. I agree, and my comment would coincide with the portion of what Commissioner Thompson mentioned about the top of Bluff. My portion of the comment would be clarify a little further the location of top of Bluff and how it coincides with the Coastal Act definitions regarding the step-like feature. I do appreciate that there seems to have been a lot of coordination and apparent agreement between the different agencies about where that is, and I'm not meaning to question that, but I do think the connection with that definition should be made more clear. I agree with other commissioner comments about the access, and Commissioner Higgins' comment in particular about more information about that pinch point and how feasibly a car or construction equipment would make it through to the other side and what to do if they can't. On public access, or let's not call it public access, on the easements through the property, I would like clarification on whether that goes to the bottom of the bluff, and any other clarification we can obtain about who has rights to what we are saying are known rights of access through easements. I think that concludes my comments. I do appreciate the public's comments regarding alternatives, and also would like at least a review of the document and confirmation that we feel that choice of just really one alternative is adequate, and why, how it relates to the significant impacts and whether or not a second one should be chosen. So those are my comments. Thank you.
Just for an understanding, you're going to take our comments, public comments received through November 30th. You're going to address those comments, and then at some point, this final, I guess, EIR will be coming back to Planning Commission for approval.
That's correct.
That's the next step?
Yes.
Concurrently, would there be a request for coastal development permit, or does that come at a later point in time after the approval of the EIR?
Typically, we do it, well, I don't know if it's typically. So we could do it either way. We could come back with the final EIR separately and then come back with the CDP after, or we could bring them both back at the same time.
Okay. Well, whether they're at the same time, I appreciate that. Whether it's the same time or there's some type of gap between the two, I am hopeful that the points that were made by the commissioners, and a lot of good points, and I think the definition of the top of bluff and top of canyon slope really need to be defined. I've got to use my notes to call it the right word. And I understand with coastal that we have agreement on some of the where the line may be as far as top of bluff. It appears we have agreement on erosion, but what we don't have agreement on is a recommended setback from that top of bluff line. And I don't really feel comfortable having, and this is similar with urban creeks, okay, on their caution of what to set back. I'm hopeful that when we get the final EIR, would be agreement between those agencies and the EIR itself, because I don't want to have to roll, I don't think we want to roll in a coastal development permit with parties not agreeing on what the proper setback is, or the definition and the setback. So if they have either Urban Creeks or Coastal has a normal setback, I think it's probably time to convince them they don't need the normal setback if you feel that there is enough evidence to show that based upon what's going on in the site, the soils, construction, et cetera, that convincing them that that's not needed because of what could happen to the buildability, the ability to build the house. But I think if we come back with differences of opinion, it's just going to open the door for other feelings or concepts that other people may have relative to if we're not in conformity with the agencies. So I would suggest trying to get there when you come back with the final EIR. I think you could do that if your evidence is really there, and you've done a lot of complete work. So plus 10, plus 25, plus 7, plus 6, whatever you agree with them, let's get an agreement and see that when the EIR comes back. I don't want to leave that as an open item, waiting for the CDP when we're just going to have to address it again, where there's a conflict between opinions on setbacks and location. Does that make sense to the commissioners? Okay. Other than that, I think this, the document itself, as put together, was, I think, was a very fine piece of work. It was easy to understand. I know it doesn't encompass everything that was in the original scoping, but I think the way it clearly laid out things for us relative to organization and going through secret requirements was a very excellent job, and appreciate that. Okay, so hopefully we can make it even better, taking into consideration the comments that we make and the public makes. And so when it does come back, we can sort of expedite our review both between the final EIR and the CDP to everybody's satisfaction. Okay? Anything else? Okay, thank you very much. And thank you, members of the audience, for your time and participation. Okay, so our next item on the agenda are commissioners' reports, and I believe Mr. Jordan's not here, so we won't have a report on staff hearing officer. We have other committee reports. Anyone? Commissioner Schwartz? Okay. Well, I want to wait a second so you can hear us. Huh? I think he's defining top of bank, I think, a little more clear. Oh, he's here.
Thank you, Mr. Chair. I attended the City Water Commission meeting this morning, and Mr. Hagmark, as usual, gave a very comprehensive update. This is on the amended Stage 3 drought declaration. A few highlights on that. Gibraltar Reservoir is at zero capacity. That's where we are. It's not painfully low. It's as low as it can get. Lake Kachuma is now at 7.5% capacity. And to that end, there was an article written in the Washington Post that generated national attention, such that Senator Dianne Feinstein's office read it and contacted Mr. Hagmark, asking what her office could do for the city of Santa Barbara to try to alleviate our pains and the exorbitant expense that we are undertaking in trying to provide sufficient water to city water users. One way in which Mr. Hagmark is investigating the senator's assistance is in trying to secure funds under Proposition 1, California Proposition 1. We've had some difficulty with that. Mr. Hagmark has encountered some roadblocks, as well as trying to secure funds from the state revolving fund loan. So hopefully the senator's office can facilitate some of that with the Department of Water Resources. Lastly, pertaining to desal. Tuesday of this week, Mr. Hagmark reported we had a major milestone in terms of some innovative underseawater pipe welding. That doesn't sound very glamorous, but it's critical to the proper engineering and restart of our desal plant. He now expects mid-February to late March of next year we will go into production. And fortunately, unfortunately, we're now having to work on plans for an expansion of our desal plant capability from the original permit renewal of 3,125 acre-feet per year to a figure above that. We don't quite know how far above that because the negotiations with the Montecito Water District are continuing, and Mr. Hagmark reported they are back on track as being productive. So depending upon how that negotiation resolves itself, we may be looking at well above the 3125. So we're developing volume and costs for all of that. and Mr. Hagmark anticipates that early next spring there will be a formal recommendation on the whole desal plant build-out. Mr. Higgins, were you going
Commissioner
to?
Schwartz, could I ask a question?
I hope I have an answer.
Sure.
I just was curious how many other communities in coastal California are undergoing desal plans, aside from those that we know about in Monterey and maybe northern San Diego. Is that ever discussed?
Not many. It's, well, I don't know, maybe Miss Ostranger. I know Miss Connect, I know from the city attorney's office, is an expert on water. The information I have is that there's a great reluctance, shall I say, these days by all of the permitting agencies to permit new desal plants. Where there are public-private partnerships proposed, there's a greater receptivity. However, with all of the environmental concerns that have come forward by the public agencies, I haven't heard that it will that there will be many, if any, new. Now, again, maybe from the city attorney's office, maybe you know more than what I've heard, but I think it's a real uphill climb by any communities who are looking kind of from the ground up to permit and build new desal plants. And in fact, what I've heard more than anything is that the permitting agencies, whether it's State Department of Water Resources, Coastal Commission, are encouraging communities to collaborate on a regional solutions, plural, and that could mean then a larger regional desal plant, but none, to my knowledge, we can ask Mr. Hagmark to report if necessary, have been permitted. So it's not like there's a runaway permitting or a highly accelerated path of permitting these. Fortunately for us, I mean, ours was a permit renewal. If we had completely taken ours down and we had to start all over again, I heard that it was not going to be highly likely that we would have a desal plant at all at this point, you know, just going it on our own as one city. So thank you very much. That's it on the water report.
Okay, Commissioner Lodge.
Thank you. Following on the water report, a couple of months ago, I had a conversation with Public Works Director Rebecca Bjork, and it was about my opinion that as soon as the 3,300 acre-foot capacity was in place, the city better start looking at increasing it and maybe going all the way to the full capacity of 10,000 acre feet. And she told me about the difficulties with financing, you know, how there wasn't more statement. I said, well, this is turning into a disaster. Maybe there's federal funding. So they apparently are looking into that, and I'm glad to hear that Senator Feinstein saw that. It's a video, and if you'd like it, I will send you the link. Okay. It's a video. They sent a reporter out and a cameraman, and it's a short video, but it's pretty grim. This area is harder hit than any place else in California. So my usual bailiwick, the Historic Landmarks Commission, you've heard about this earlier today at the noon meeting in part, but staff announced yesterday that the guidelines, the draft guidelines that the HLC, when they got started a lot sooner than the ABR on the guidelines relating to finding compatibility and the difficulties they were having with the AUD projects. They got started before the ABR, but that staff is trying to get both of them ready to come to us, both versions to us on December 8th. That doesn't sound right. Is that the correct? Is that a Thursday? Okay. Okay. So that, so that's what's. Yeah, okay. So it's December 8th. That will be coming to us. And then you also heard from HLC Commissioner Grumbine at noon about the project that was before HLC at State and Pedregosa, in which, as he said, HLC just sort of gushed over it because it was such a well-thought-out project with a huge amount of livability, unlike many of the projects we've seen come before us, but it is low density. It's only 14 dwelling units to the acre. Also very very nice Santa Barbara design. So they were very pleased with that. They did have some questions about the arrangement of the parking lot, but that project is going forward in this format, in an AUD format, because with the reduced parking requirements, they were able to develop this particular program, which is 4 separate buildings, and which then means more light and air around for the dwelling units. So they were really, as he said, they almost gave it full design approval without full plans.
Underscore that if you have a chance. It's the last item on the agenda. I was watching it as well. There's a real good interchange on it, and I think they have a picture, just like a number of the projects that we see coming through AUD. They were formerly under a variable density or condominium type program. This is one that converted, which is good, converted to a AUD project. But it does mark what a difference parking makes. The before, where they had pretty much large buildings that weren't really approvable, to a good degree, and with the reduced parking, and they had some more flexibility in reducing the size, bulk, and scale. So I think they did a good job, and everybody appreciated it. And kudos to HLC as well for accepting open parking, the way they did, with good suggestions on modifications that made it work as well. There were a lot of good offsets to that fact. So if you are interested, it's the last item on yesterday's meeting. Thank you.
And I wasn't alone one either.
No, it wasn't. It wasn't. But it was good to see. It was good to see they were happy with that. And maybe that'll come up in discussion when we talk about design guidelines, when we're with them as an example, let's say, that particular project. It's good to hear about some good ones that people were happy with as well. Okay, anything else? Okay, thank you. We are adjourned till December 1st. And again, Ms. Ostringer, thank you very much for joining us. And we'll see you soon. And enjoy Thanksgiving. I guess that's the next. Happy Thanksgiving.